Aloha, aloha, my kako. Good morning, everyone. This is the July 10, 2024 Land Use Commission meeting. This is an in-person meeting, which is physically being held at Leopapa a Kamehameha State Office Tower, room 405-235 South Beretania Street, Honolulu, and it's open to the public. Court reporting transcriptions are being done from the Zoom recording of this meeting. For all meeting participants, I'd like to stress the importance of speaking slowly, clearly, and directly into your microphone. Before speaking each time, please state your name and identify yourself for the record. Even though this is an in-person meeting, please be aware that all meeting participants are being recorded on the digital record of this Zoom meeting, and it will be posted to YouTube, and it will be used for court reporting purposes. Your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit the meeting now. My name is Dan Giovanni, and I have the pleasure to serve as the LUC chair. We currently have 9 seated commissioners, 7 of which are here in attendance today. Along with me are Commissioner Michael Yamane from Kauai, Commissioner Mel Kahele, Commissioner Brian Lee, and Commissioner, I think that's it, from Oahu, huh? And Commissioner Nancy Carr Smith from Hawaii Island, Commissioner Bruce U'u from Maui, and Commissioner Miles Miyasato, also from Oahu. I missed that. He's from Big Island? Oh, that was an error in my notes. I apologize for that. So Commissioner Miyasato, my apologies and welcome from Hawaii Island. Excused from today are Commissioner Kamakea Ohelo and Commissioner Hayashida. Also in attendance are the LUC Executive Officer, Daniel Orendanker, LUC Staff Planner, Martina Segura, LUC Chief Clerk, Ariana Kwan. And joining us by Zoom is LUC Attorney General, Melissa Goldman. Again, the court reporting transcriptions are being done from the Zoom recording. At this time, the chair would like to take a minute and reflect upon a former commissioner who we unfortunately lost this past weekend. Mr. Aaron Mahi, a great statesman, a great musician, a great representative of our state, also served as a commissioner on this commission for several years. I had the pleasure to work with him for about 1 year, and it was inspiring to be in his presence. Mr. Orendanker, do you have anything to offer on this point?
Yes, Mr. Chair, thank you. We've prepared a couple of statements, and we're going to show a video of Aaron and one of his one of the music projects that he was involved in. But first, I'm going to say a little bit, and then after that, we'll show the video, and then I'll read Arnold's statement. Arnold couldn't be with us today, but he wanted to say something. I thoroughly enjoyed Aaron. Aaron, as we all know, was one of the giants in the Hawaiian cultural community and the music industry. He was one of the most loving souls I have ever met. I only saw him angry a few times, and even then, it was righteous anger. He was passionate and cared deeply about the people and the Aina. He brought a light to the commission while he served, humor and wit, as was his way, and a tremendous ability to express himself. Arnold has a couple of specific stories about things that he did on the commission that I will talk about later. But Aaron was adept at providing some kind of story for each meeting that he was a part of. I actually met Aaron long before he became a commissioner. Well, I was putting together a Christmas party for Windward community, and I called him up to see if the Royal Hawaiian Band was willing to play. This was when he was conductor. And not only did he come and put on a tremendous performance for the community, but he activated all the cultural practitioners on the Windward side to come to this thing. And it turned into an incredible, incredible evening. I thanked him for it and I'll never forget it. Having him on the commission was a pleasure. I have a personal story to tell about Aaron that kind of gives you an idea of what a humble and giving person he was. We were headed to the hearing one day from the airport, and Aaron just started sighing. And I said, Aaron, what's wrong? And he said, in 2 weeks, I have to go to New York City and do a performance. A friend of his was being ordained as a minister in the church, and it was going to be a big deal. And she had asked him to come. She had Hawaiian roots, and she had asked him to come and play. And he said, I can't find anybody who plays the ukulele to go with me. And at the time, my stepson, who is a tremendous musician, was living in New York City. So I said, well, Aaron, why don't you I know Kalani can play, ukulele. Why don't you give him a call? So he called up Kalani and they got together, and it was one of the most incredible evenings that Kalani has had in his 35 years on this planet. Not only did Aaron have him play with him, but he took him to the backroom party, and there were all these really tremendous performers back there, both from the mainland and from Hawaii. And Aaron just made him feel like he was part of the family. And that was Aaron. He'll be sorely missed by the entire Hawaiian community and by all of us here. And Ariana, can you play that video now? This was a project that Aaron was involved in putting together. Thank you for indulging us, staff, a little bit with that. Now, Arnold wanted me to read a couple of things. Arnold Wong, former commissioner and now staff member. And I'll read them verbatim except when he screws up. There are no words to explain how to say you're going to miss a friend and a colleague. For those of you who worked with Aaron, it was a pleasure to listen to some of his zingers. For the rest of you, let me give you a glimpse of the side of Aaron you may not have known. When I first met Aaron, I said, wow, I'm going to work with a celebrity. He was a musician and led the Royal Hawaiian Band. I was in awe due to his status and found out that he was down to earth with a heart. I really found out that when we had to work on the executive officer's evaluation form at his church. Due to our schedules, we had a lunch meeting. It was then that I found out he had a sense of humor. We were so wrapped up in talking story that we forgot why we were meeting and had to do another meeting for our original purpose. He sometimes got pissed off at a hearing. He was told this actually was a hearing on Molokai, and Aaron had roots on Molokai. And at one point, a young gentleman came up to testify and berated the commission for being outsiders and not knowing anything about Molokai and the cultural resources there. What actually happened was Aaron got so upset that he was being accused of not knowing anything about Molokai that he went out after the hearing when we were getting ready to go to the hotel, and he took it out on Jonathan Scheuer. He wasn't chair at the time, he was on the commission. And I came out afterwards and Jonathan was standing in the parking lot shaking and white as a sheet. Aaron was just venting, but he was, when he got passionate, he got passionate. As the cultural expert, we looked to Aaron for guidance. It was very amusing when some of the locals would not listen to him or his wisdom. It was also funny that Aaron would tell them due to the law, if we did not render a decision, we had a hearing on Maui, and we had 200, it was Oluwalu, and we had 250 people come to testify, and Aaron finally stood up and told them that if they didn't start keeping their testimony short and not repeating themselves, that the petition was going to be automatically granted. The other story that Arnold wanted to me relate about Aaron was we were doing Waimanalo Gulch several years ago. One of the many times we did Waimanalo Gulch. And it was clear that the county did not know what it was going to do, and was just there to kind of prevent us from lifting the SP. And so Aaron all of a sudden starts saying, you know, this is half baked. And he went through this long kind of analogy about how to bake a lasagna. And by the time he was done talking about baking lasagna, we had to break for lunch because everybody was so damn hungry. Could almost smell it the way he was describing it. He was just very, very, very good with words. These stories and many more reminded Arnold of Aaron. And I, for one, this is Arnold saying this. Arnold will remember him as a friend and a colleague forever. Thank you. That's all I have.
Thank you, Dan. Last time I saw Aaron, he was in front of this commission as a testifier, a community representative, still caring about land use issues and wanting us to do our job in a Pono way. Just a real citizen of Hawaii, and he will be missed. So thank you everyone for indulging us to acknowledge in memory of Aaron. Okay, let's go on. For our next order of business will be the adoption of minutes from the meeting of June 19 and 20, 2024.
Mr. Chair, I'd like to make a motion to approve minutes.
Thank you, Commissioner Yamani. Do I have a second regarding the minutes?
Second.
Commissioner Carr-Smith, thank you. Any questions or comments on the minutes?
I wanted to make a comment per staff's suggestion. There was just a misspelling of my last name a couple of times and added hyphen. So they know that it doesn't have a hyphen.
Oh,
So
okay.
just mentioning that.
They spelled Smith correctly?
Yes, they did.
Okay.
Thank you.
Will be noted. Thank you. And just to confirm, we've received no written or testimony on the minutes,
No, Mr. Chair.
and no one has signed up to testify on the minutes.
No, Mr. Chair.
Okay, fine. So let's take all in favor of adoption of the minutes as moved, signify by saying aye. Any opposed? None. So the minutes are adopted. Next order of business is our tentative meeting agenda and schedule, not agenda, but schedule. Mr. Orendanker.
Thank you, Chair. July 23rd and 24th, we will be at the Foreign Trade Zone here on Oahu for commissioner training. On August 7th and 8th, we have scheduled hearings on the Waimanalo Gulch Sanitary Landfill. Those will be at the airport. On the 21st and the 22nd, we will be at Philca. Yes. August 21st and 22nd. We will be hearing the Makakilo Quarry matter. We have a couple of tentative dates with regard to Makakilo Quarry because we're not sure how long it's going to take. And as you know, we have a 45-day deadline for special permits. So we have tentatively, and these are not confirmed dates, the 29th for possible continuation of Makakilo Quarry of August. And then September 10th for the adoption of the order. That would be a Zoom meeting if it comes to that. The 11th, 12th, and 13th is HCPO on at the Hapuna Beach Resort on the Big Island. September 25th and 26th. We have tentatively scheduled hearings on Maui to the city and county's motion to remove portions of the waste facility over there from IAL, and on the following day to add IAL. We're not sure whether the county's still going to do that or not. We'll keep the commissioners apprised. On October 9th, we have a hearing on Oahu, destination to be determined, or location to be determined for the RK2 partners, motion for declaratory ruling. On October 23rd and 24th, we have tentatively scheduled the Mahi Solar matter on Oahu. On November 6th and 7th, we will be on Maui for an A and B properties motion, and on the 7th for the Emmanuel Lutheran status report. We don't have anything currently scheduled for November 20th or 21st, or December 4th, 5th, or 18th and 19th.
Thank you. So with the exception of that one meeting on September 10th, all other meetings are anticipated to be in person?
Yes, that is correct, Mr. Chair. At this time.
Commissioners, any questions or comments on the tentative schedule?
Chair?
Commissioner Carsmith.
Thank you. Dan, I'm not sure, you mentioned a declaratory ruling on October 9th.
Yes.
So is the declaratory ruling something that the commission decides?
Yes,
Whether to
it
proceed with?
is.
So you're suggesting this, is that correct?
Well, declaratory rulings are funny animals. There are three ways you can dispose of a declaratory ruling. You can decide on the pleadings, but not us, the commissioners decide, which doesn't require a evidentiary hearing. You can we have 90 days to complete this, by the way. That's one of the reasons it's on that date on the schedule. You can hold a hearing where the parties present oral argument, and then render a decision, or you can schedule the hearing on the declaratory ruling for a later date and have an evidentiary hearing. So, it depends on how the commission determines it wants to dispose of it, but staff does not dispose of declaratory rulings.
But it came to the agenda via staff?
Well, they filed a motion for a declaratory ruling.
Oh, they did.
Yeah.
RK2 did.
Yeah.
Oh, okay, okay. Thank you.
Just to confirm, that filing is posted?
It is still being reviewed and it's not an official filing yet. We're waiting for their filing fee.
Yeah, they haven't paid their money.
Okay, so would you please send out a note to all commissioners when it's posted so that we know proactively that it's there and we can review it?
Will do, Chair.
Thank you very much. Anything further on the tentative schedule? Okay. Thank you. Our next order of business is a presentation by the Hawaii State Ethics Commission. It's live training. I want to welcome Mr. Robert Harris, former colleague, to take a position. This training session is being conducted by the Hawaii State Ethics Commission and will cover the key provisions and guidelines outlined in the Hawaii State Ethics Code. The session aims to educate the commissioners on ethical standards and requirements, including conflicts of interest, gifts and hospitality, confidential information, and fair treatment. The training will provide practical examples and scenarios to ensure a comprehensive understanding of ethical obligations and promote adherence to state ethics laws. Ariana, has there been any member of the public who wishes to testify on this agenda item?
No, Mr. Chair.
So we'll now, Mr. Harris, would you introduce yourself and give us an idea of the length of the presentation?
Aloha, my name is Robert Harris.
Is your button on?
Aloha.
Lights.
Justin?
Thank you. Aloha, my name is Robert Harris. I am the Executive Director and General Counsel for the Hawaii State Ethics Commission. This is a general ethics training. It will last approximately between 45 minutes to an hour, depending on the number of questions or how much we want to talk. So if that's okay, I go ahead and get started. Or-
Yeah, I'd like to thank you again for being here and doing this in person. And let me encourage the commissioners, would you prefer they hold questions to the end or as you go?
I am happy to talk about that sort of in depth. We are a small enough group, and I recognize even though this is being recorded and streamed, that I'd be happy to have a conversation. So if something comes up, feel free to jump in. If it's something that's going to be covered later in the presentation, I'll just go ahead and.
Oh,
let
that's
you know.
great. That's a good way to handle it. And just FYI, if we happen to go long, I'll probably take a 5-minute break somewhere around 11 o'clock or 11:15, just to refresh everybody, and then we'll resume. So why don't you proceed?
Thank you, Chair. Thank you, Commissioners, for taking the time to be here, and thank you for your service. This is bringing back memories about 25 years ago. As a law student, I took administrative procedure, and it was a requirement that we had to testify before an administrative agency. And so I came to the Land Use Commission and testified on, I think, some constitutional points. To my horror, at the time, Commissioner Bruce Copa started asking some very detailed and specific questions, which I was utterly unprepared to answer. I hope I'm better prepared today. So again, thank you for the opportunity to be here and to make up for that experience. Hawaii has a unique distinction of being the first state to have created an independent ethics commission, an establishment in the Hawaii State Constitution, and established a requirement that the people, state employees, and we'll get into what that means, but officers, state employees, need to exhibit the highest standards of ethical conduct. And those standards come from the personal integrity of each individual in government. Following the adoption of this, a number of states actually started duplicating what Hawaii's created and has become a national model. Again, Hawaii was the first state to do that. We are also the founding member of COGL, which is the Conference on Governmental Ethics and Law, which is now an international entity. And again, Hawaii was one of the founding members of that organization. I say that just to say that we have some pride in history. Doesn't mean we don't have work to do, but it is something that we should be proud of, and it is something that, Hawaii is a clear leader on. So the state ethics code, our constitution requires each political subdivision to establish an ethics commission. So there are county ethics, either boards or commissions, and there's a state ethics commission. State ethics commission has oversight, and the ethics code applies to legislators, state employees, and members of state boards and commissions. For purposes of the ethics code, just in case this gets confusing later, the definition of state employee is really broad. It includes volunteer members of boards and commissions. So even though we classically wouldn't think of you as an employee, for purpose of the ethics code, you're lumped in as a state employee.
Robert, does it include state Hawaii Supreme Court justices?
Good question. Ethics code applies to all employees of the judiciary, but it does exempt justices and judges. They are subject to the code of judicial conduct and have their own separate review board for that. There are approximately, or there are over 60,000 state officials and employees. So the ethics code in general you find is fairly general, and it was deliberately passed that way because there's a recognition that some degree of flexibility needs to apply to the different facts that happen and to the different situations. And so there's always a balance of trying to make sure that that government agency can function, but also trying to balance the requirement of the highest standards of ethical conduct. And so that is part of the role that my agency, the Ethics Commission, tries to serve under. It is trying to make sure we're able to apply the code to each individual fact situation. And so sometimes when people are saying, I just want a clear answer, can I do this or this? The answer, unfortunately, too often is a little bit of a, it depends. And the reason why we do that is because the flexibility of trying to address different circumstances, different situations, running from an employee that is, more of a blue collar situation to say a UH professor and sort of the wide gamut that runs between that. But again, holding that ultimate standard of highest standard of ethical conduct in mind. The Ethics Commission provides education, advice, we do enforcement, and we also handle all of the disclosures and make sure those are available for the public. Let me just pause there for a quick second because I really want to emphasize the advice part of what the Ethics Commission does. We have a attorney of the day who is specifically assigned to basically sit there and handle any phone calls, any inquiries, emails, and to be able to do that on a confidential basis. We want people to come forward to us. Again, advice is prospective. If you did something wrong in the past, we're not going to be able to do as much about it, but prospective situations, what do I do about this coming up? And again, we handle it in confidential, and even if it winds up being some type of enforcement action, we won't use that call as a basis to start enforcement. We want you to feel comfortable in calling and asking questions. And let me be a little bit more specific about this. Part of the purpose of the Ethics Commission is to help maintain public confidence in government generally. We have as much of an interest in keeping your name out of the paper for an ethical misconduct as you do. We have a shared interest there. And so the idea is to try to make sure that we're able to help advise and help give clarity. There are situations where we'll provide advice letters, for example, that you can keep. And so if someone asks you a question, you can say, I talked to the Ethics Commission, they gave me a letter and I followed their advice, right? That helps ensure confidence that things were appropriately handled in the best way we can. So again, let me emphasize, please do not be afraid to call and ask for advice if you have a situation coming up in front of you. Okay. So one of the bases that we are here is that there is now a mandatory ethics training requirement for all state employees. We have approximately 82%, I think, of all state employees currently have taken a mandatory ethics training, and that there is a subset of folks that are required to take a live training that includes this body. So I appreciate you being here and participating. And anyone else who is a state employee who is not sort of in the what I'd call high profile boards, commissions, or sort of a high level can take our online self-directed training, which is available on our website.
Robert,
Mhm.
quick question. So we have two commissioners absent today. Is it mandatory that they find a way to get this training from you?
Sure. Good question. Yes. So as you can see that they do have an obligation within 90 days to take the ethics training. We do offer live trainings approximately once a month. They're available on our website, and I'll show you the link in just a second so they can easily sign up. I believe our next one is the 23rd. So they sign up and take it, they'll get credit for that as well.
That'd be by video.
It is via Zoom, correct. And it will be substantially similar to this. There's an opportunity, obviously, when you have something specific to agency, we can tailor a little bit. This will be a little bit more general if they take that. But again, it meets the requirement and should hit all the important topics.
Thank you.
Sure. So this will meet your requirement for the next 4 years. We do keep a record of that. We also can issue certificates, which you can keep too, just to make sure you have in your records to say, hey, I met this requirement. So this is our website. It has a bright green button on it. When you get to it, it looks literally like this. So it makes it very easy to find where to hit the training requirements. And then it does have the sign up link for all the live training in the future. And again, I'm sharing this for anybody who may be watching it from the public, but also for other staff, employees, et cetera, that need to meet this requirement. Okay, so our program, we're going to cover a bunch of different topics, and we're going to try to loosely group them together and also talk about when we meet, we switch into different topics. For any of you who have taken philosophy or sort of studied ethics or thought about ethics in general, this isn't necessarily that. This is a code. It is a directive. Here are the things that you're supposed to do or not do. And so it's less theoretical and maybe more applied. And so walking through a code, just as if I were to walk through the tax code, may not always be the most exciting thing. I do hope you ask questions. We do have hypotheticals in here, again, to try to make sure you're thinking through what it is. But again, I recognize some of the stuff may not be as applicable to what you do on the Land Use Commission, and some of it may be very applicable, and I encourage you to try to ask those questions when that comes up. Okay, so these are the different topics we're going to go through. I won't read them for you. I assume you can. And let's start with gifts. No problem. So we have a general standard on gifts given to state employees or board and commission members. It's the same one that's in almost every single state in the United States, and it's pretty close to the federal standard too. It says essentially, don't accept any gift if it is reasonable to infer the gift is offered to influence or reward you for official action. I attend a annual ethics conference, and every state and every jurisdiction says this tends to be one of the most controversial things. Tends to be more legislators, to be frank, who complain about this. State librarians, for some reason, never ask me much about gifts that they're being offered. But the key thing I'm going to strike here is that this is from a reasonable perspective. If you don't mind, go ahead and go back. From a reasonable perspective, so it's what like a person in the public would think, not necessarily you, right? So you might think, hey, a Manapua is not going to influence me, right? I don't need a Manapua. I'm on a diet or whatever it may be. But the point is, it's not what you specifically would think of the situation, but it's what a member of the public would think. And so we try to strive for that. And this standard of what gifts can or can't be given has evolved over the years. And so you want to try and stress something you may have heard 5 or 10 years ago may no longer be true. So please pay attention. So the next slide, what is a gift? The legal definition, essentially anything of value, is fairly broad. So it can apply to anything from gifts of a golf trip. It can apply to food, travel, or just gift baskets in general. Again, generally, if it has value and it's being given to you, it's likely going to meet the definition. So in 2020, the Ethics Commission adopted a 3-part factor test to determine if you can accept a gift. There's also a list of things that are specifically exempted from this rule, and we'll get into that in a little bit. The 3-part factor test, and you can imagine how exciting it is for people who say, well, can I take this gift? Let me apply the 3-part factor test. Maybe a little bit more challenging we like. The idea is it tries to create some flexibility of situations when gifts really benefit. And so it allows us to have more flexibility, in saying when people can take something. It is not as bright line or clear, perhaps, as we'd like. So we're going to take another stab at trying to create some more exceptions to create more of a bright line rule. The thing that we're going to look at, stay back. We typically are going to look at is the relationship. So we're going to really talk about this more in depth in a second. We're going to look at the value of the gift, and we're going to ask, is there a state benefit to accepting this gift? So next slide. So looking at the relationship, typically if it is being given by somebody that you inspect or regulate, or as a vendor or contractor, or as a lobbyist that appears before you, we generally are going to say you can't accept gifts from them, and fairly obvious reasons, right? So if it's the Public Utilities Commission and Hawaiian Electric's offering a gift, typically we're going to say, hey, it's just not appropriate. You should accept it. And that's the relationship test. We're going to look, are they asking you to take some type of official action where you're going to make a decision on something that impacts them? That's the type of situation we're going to say, hey, pause, it's not appropriate. Next slide. We're also going to look at what the value of the gift is. And again, sort of a sliding scale. If it's worth a lot, we're more likely to say, hey, maybe that's inappropriate. Or if it's something de minimis or nominal, we're more likely to say that's fine. Next. And then probably the most important one is there a state benefit? So examples we'll talk about in a second might include travel. Someone's offering to pay for you to attend a conference where you're going to learn something that's going to substantively allow you to do your job better. It's a pretty high state benefit, right? We're more likely to say yes to that type of circumstance. versus something that is just purely entertainment. Someone wants to give you a gift, say to a Taylor Swift concert. I say there's really not a lot of, I mean, it sounds fun, but not a lot of state benefit to that, right? And so that's sort of how we're going to look at those things. So a county official who appears before the Land Use Commission offers a gift basket to one of the commissioners. Can that commissioner accept? Show of hands, yes. Show of hands, no. Great. This is going to be a fun session. Thank you. All right, next quiz. A developer meets with Housing Director Zoe about an affordable housing RFP and offers to pay for dinner. Can Zoe accept? Show of hands, yes. Show of hands, no. Let me add an additional question. Can Zoe meet with that developer and have dinner? Just in general, if she pays her own way? Yes, absolutely, right? I mean, the intent is not to stop interactions and discussions, right? We want government officials in general to be responsive to the public, and so that's fine. It's just the idea is that there's sort of a line of, hey, you know, I'm going to pay for myself. Let's go ahead and have that conversation, and that's hopefully the culture. You know, we want people to perceive government to have. I don't need to buy things. I don't need to provide food or other items in order to get serviced. Again, we sometimes will get pushback and say, well, hey, what about gifts of aloha or you know, the cultural experience, right? Gifts of aloha in my mind are typically if I have tangerines, I give to my neighbor. If they have mangoes, they give to me, right? There's not an expectation. There's not an expectation of reciprocity. And there's not an expectation they got to do something for that, right? The problem is from a member of the public, if they see one government official having mounds and mounds of food every day being piled up in front of them, the perception might be, I've got to give food in order to have service. I got to give food in order to be seen, right? And no, right? We're here to service the public in general, and the expectation is no, you don't need to do that. So there are some specific gift exemptions that are provided. Go ahead, next slide. There we go. So typical exemptions include gift of lay, not money lay, but lay. Have to say that. Sometimes people say, well, but lay are really can be really expensive. It's just per se exempted. So even if you get a, you know, really exotic lay that's worth hundreds of dollars, you know, that's per se exempted. Nominal items that essentially are things that you get at a conference, like they have somebody's name on it or something like a pen that normally you wouldn't be able to resell. That doesn't really have any value. We say that's okay. It doesn't mean that if it's like a Yeti cup that has someone's name on it that has some value, you know, we'd say, okay, no, you shouldn't take that. But pens, pencils, Trotsky, you know, just small things are okay. We also recognize in this sort of teacher situation, gifts of sort of nominal value that are connected to something specific that nobody would reasonably think was really intended to influence reward. So the gift of an apple to a teacher kind of circumstance. But again, the intent there is it's supposed to be nominal. If you have any questions about something that's being offered to you or something along those lines, if it would fit within the exemptions, I encourage you to call us and talk to us about it. And again, we are in the process of working at admin rules to try to create some more exemptions, again, to create more bright line scenarios. Okay.
So I got two questions on gifts. So maybe it's my ancient memory, but I used to recall something like a $50 rule. Is that relevant?
So inflation may have hit your memory. It was $25. There used to be a gift of aloha, $25. We have moved away from that, and we have the factor test. The rationale for that, number of different reasons. We had lots of calls where people got something that was $29.99 kind of circumstances, and just it started becoming very arbitrary. There'd be circumstances, for example, if somebody wanted to give you during COVID, wanted to give you PP, protection devices that worth more, served as state benefit. We want to be able to say, yeah, that's entirely appropriate, right? So we move to something that creates more flexibility, not quite as bright a line. So that rule no longer applies, and you know, part of this training is to actively say, you know, that's no longer something to look at.
Good. The other potential conflict I see is the practice of omiyage,
Mhm.
which my wife is receiving things almost weekly from friends that travel and go places and we see occasionally. And it's just part of the culture. How does that factor in?
Sure. So again, something that's received in your personal scenario. So a personal situation, personal friend. And again, when I say this, I want to be really clear, not somebody you met in the scope of being on the land use commission or scope of a state employment or state board or commission. So like a neighbor, for example, that's entirely appropriate. You're not being given it because of your position. But if it's because of your position, that's when we start drawing the line. And the idea is
That's
essentially say it's not necessary, right? It's not
Yeah.
expected. And sort of within an office, like with peer employees that are peers of one another, again, we generally say that's okay. But we also try to avoid the supervisor underling kind of scenario where maybe there's an expectation or some type of perception of impropriety in that.
Thank you. That's helpful.
Sure.
Commissioner Lee.
Mr. Harris, can you comment on the slight variation that Honolulu County's rules have on what you just said? Thank you.
Yes, the Honolulu County just adopted new county code, and they have gone in a different direction. There's a lot of similarity, but they've gone in a different direction, and that is just that it's a mix of a couple different things. Obviously, when you have two different jurisdictions, they may go in different directions. That happens. I think also they were trying very hard to get that ordinance passed for over a year. So I think there's probably some give and take that happened there. I think again, the benefit of having a dollar value, and a number of states have done that. I've just said anything below, is it is a lot easier to apply. We also see a lot more abuse that happens with that as well, right? And so I think the intent here was to try to build something that's more flexible, but also was able to try to prevent some of the abuse that was happening. Gifts of travel. If you are offered by a non-state or federal agency a trip to a conference, for example, we do have on our website a questionnaire. You're not required to fill it out. However, if you do, we ask some basic questions like who's paying for it, what's the agenda, why are you going? We do issue a letter back to you, essentially saying, hey, this is allowed under the ethics code and it's something you can keep. So some agencies have made it a practice to always do that for gifts of travel, just in order to have that assurance. Some of the things that we will require, for example, is it's supposed to be modest food, modest lodging, economy travel, economy plane airfare, for example, which is a DAGS requirement, just to be clear for all state employees in general. But the idea is, we generally do say yes to this, particularly if it's a genuine bona fide conference where you're going to have some educational opportunity or benefit. Next. So Sean, a UH Hilo curriculum specialist, was invited to go to an education conference. A federal grant will cover his travel costs. Can he go? Show of hands, yes. Anybody say no? Yeah, absolutely. And in fact, this is kind of a even easier question than it sounds, because it's a federal grant. It's not even a gift. We would generally speaking just say yes to that. So there's a second requirement. Again, a lot of people confuse these two. I want to be really clear. There's a can I accept a gift? And there's the next question is, do I have to report it?
Go
Right?
back a slide.
Let's go back a slide.
So I go to this conference and it's a morning session. In the afternoon, we all go play golf. And the golf is included in do I have to discriminate and pay for my own golf?
Yeah, so those are types of questions that we would go through if you were to ask a travel, ask for a travel request. We'd say, hey, the golf is typically going to be an entertainment function. There's really not a state purpose. We'd encourage you either to not attend or pay for it yourself.
Yeah.
Just like if there was a rock concert or something along those lines, there's really not a state benefit to being at that part of the conference. So gift reporting, if anyone receives a gift from the same source that's worth more than 200, and it can be gifts like plural that cumulatively are worth more than $200, and the source has interest that may be affected by your official action, to be clear, we read that pretty broadly. If you're being given the gift in your official role, like you're being invited as a land use commissioner to attend a event, a function, a conference, we'll probably expand that and say it's, likely that this would probably apply. We'd encourage you to report that, or we would require you to report that if it's over $200. Reporting deadline is June 30th, and it applies for the calendar year previous. So quick summary, don't accept a gift if it reasonably appears the gift is intended to influence or reward you. Report gifts over $200 from anyone who may be affected by your actions. And you can't accept a prohibited gift just because you report it. Okay. All right, let's move on. Actually, let me pause for a second. Any other gifts questions? Okay. If you're legislators, I'd be getting a lot more questions. Fair treatment. So this is a pretty broad term that applies for a lot of different functions. It generally speaking means you can't use your state position to obtain unwarranted privileges, advantages, or treatment for yourself or others. And we're going to get into some very specific parts of this, but this is the general overview of what it means. Next. So may not be as applicable here, but you cannot use your state position to obtain outside employment or contracts for yourself. Let's give an example of that. Next. Celia, a utilities regulator, is reviewing Oahu Solar's permit request. Again, anybody who's familiar is probably going to say that doesn't really happen, but just please go with it. She plans to leave the agency. Celia meets Oahu Solar CEO and asks if they need a compliance officer. Is that okay? Show of hands, yes. Show of hands, no. Thank you. So yeah, in this circumstance, the perception is that the Oahu Solar might feel compelled, because this is somebody regulating me, that I'm probably going to have to try to hire this person or give it to them. And it appears like she's using her position in order to get this job. Now, if it was an open job offer, for example, and she just applied, it'd be a different circumstance. In that circumstance, I'd probably encourage her to talk to her supervisor and recuse herself from anything involving this company and make sure that's transparent and clear. But again, the idea is you can't use your position to try to get employment. In some ways, that's leveraging it. Go ahead.
So for every petition that comes before us, if Oahu Solar came before us, as a matter of course, we ask the commissioners to disclose whether or not they have any potential conflict, real or perceived. And then based on that, we invite comment if anybody has issue with that. And we will make a decision to have that person participate or not participate in that specific hearing. Is that protocol a reasonable way to deal with some of this type of potential conflict?
Absolutely. I think it's a great standard. We do have a separate conflicts of interest section that we will get into that also applies. This is really looking at using, so for example, in that hypothetical, if halfway through the proceeding, I'm sure none of the commissioners here would do this, but if one of the commissioners were to call a
Yeah, that
petitioner
happens.
and
It
say,
happens,
hey,
yeah.
are you guys hiring, right? That, this would not only be a conflict of interest, it'd also create a fair treatment issue. So there'd be two violations that we'd be looking at.
Yeah, it's not uncommon, for example, during the course of an evidentiary hearing where there is a witness that might come forward and present. And a commissioner may have a relationship with that. So even at that point in time, we'll invite a disclosure and then deal with it.
I do want to separate, because we are going to talk about what is a conflict of interest for purposes of the ethics code. And that may be different. That may be more apropos of what you're saying versus somebody using their position affirmatively to get an advantage, right? So I'm going to try to get a job, right?
Yeah, something of value.
Yeah.
Yeah.
Let's go ahead and go to the next section. So in addition, state employees and board and commission members are not allowed to accept double compensation performing your state duties unless permitted by law. So I recognize you are all very, very well paid for the current positions you have. Thank you. Thank you for your service.
Right?
Yeah. Example for this might be is someone saying, hey, you guys are doing a great job. I'd like to give you a couple $100, right? This would apply. We'd say, no, I mean, this is it's a volunteer unpaid position. You're not allowed to take money as a attempt to appear to reward or influence you in some way. This comes up in the question of honorarium a lot. If someone's speaking in their state capacity and speaking on something they know, for example, director of DOT is talking about future state projects, and someone, offers them honorarium, would say, no, hey, it's part of your state job. You're not really supposed to get double compensation for that. Maybe you deserve to be paid more. Maybe all the board and commissioners deserve to be paid, right? That's a valid conversation, but you shouldn't individually try to take advantage or get compensated from it. Don't use state time, equipment, facilities, or other state resources for private business purposes. Let's break this one out for a second. Go ahead to the next slide. What is a private business? It is a very, very broad term. It includes both for-profit and nonprofit organizations. It also includes political campaigns. Broad term, private business. Next. So examples would be is not doing outside work for a private employer while on state time or state resources, or state facilities, selling foods, crafts, etc. to coworkers, fundraising for private clubs, organizations, or charities, campaign activities such as asking for campaign contributions, campaign events, etc. Next. There are some exceptions that have been built in for fundraising that have been expressly recognized. They include Aloha United Way, Hawaii Food Bank, and Blood Bank of Hawaii, where state employees are allowed to do fundraising around these specific entities. In addition, the governor and the Senate president, the speaker, and the UH president are allowed to designate other specific fundraising situations. But again, just in general, we say, you're not allowed to do that on state time. Okay. In addition, under the fair treatment, you're not allowed to use state property for a private business or private use. So you can't take a state equipment or machinery home for private personal use. All right, so Rich works for the Land Use Commission and volunteers on a nonprofit board. Rich uses his agency's Zoom equipment to help his nonprofit run a meeting. Is that okay? Show of hands, yes? Show of hands, no. Seems really easy when I put it in context of this, but we do see this pretty often because people just want to help out, right? There's that sort of aloha compassion. Oh, of course, I can use it. It's not being used. I'll just take it to be used for this thing. But then if it, you're providing a benefit to that one nonprofit and all the other nonprofits have a similar expectation of, why can't I use it? There's nothing stopping, for example, if the Land Use Commission wanted to make this facility open to all nonprofits, it wouldn't be a fair treatment issue. But if you start saying only this one or only that one, now we start having a fair treatment issue. Okay. Next. And I think this is the final subsection of the law, which says you can't enter in substantial financial transactions with subordinates or those you supervise or inspect. So maybe being a bit specific with a hypothetical that I haven't really thought through, so forgive me if it winds up failing. If Dan wanted to sell his car to Dan, we would say, hey, no, you're not allowed to do that because there might be an appearance of coercion or an appearance that, I've got to accept or I've got to say yes. Even though maybe it's a perfectly above board transaction, we'd still say that's a violation. Okay. Loan, sale, those kinds of things. So Jaina, a food inspector, works as a real estate agent on the weekend. During an inspection, she offers to help the restaurant owner find a new location. Is this okay? Show of hands, yes. Show of hands, no. Right, so this is going to go back to the discussion of, essentially trying to find, again, this hypothetical may not be as well written as I'd like. The earlier discussion we had about not trying to find outside employment, the assumption here is if she's going to get a commission for finding a new location, she's using her position as the food inspector to basically say, hey, can I represent you as my part-time weekend job? And so we'd say, no, like this is inappropriate. Again, the hypothetical is not as clear as it should have been, but you can't pick up outside real estate work while you're in your position as a food inspector. Okay. Quick summary, don't use your state position to get outside employment. Don't accept double compensation, or maybe I should just say compensation here. Don't use state resources for private business activities, and don't enter into substantial financial transactions with subordinates. Any questions on fair treatment? This is one of our bigger topics. Just to be clear, we have one other, which is conflicts of interest, and then the rest of the sections get pretty fast and quick. So bear with us. We're making good time here. We do have a new nepotism law. I'm not sure if it will necessarily come up in the context of the Land Use Commission, but just so you're aware of it. State employees, state board members, except employees in the legislative and judicial branches, are not allowed to hire supervisor. Go ahead and go to the next one. Are not allowed to take action affecting relatives or household members. So actions would include employment, hiring, supervising, or awarding or administrating contracts. Okay, next. I think we can skip this one. Okay, let me just quickly say on the nepotism, we do have a good cause process where if there is, for example, only one employee or one person applied for an open position, it was important to fill that position, and the agency has done a really good job of advertising and just there's nobody else available. That's a type of situation where the Ethics Commission has the ability to give a good cause exception to the nepotism law. As a public process, the idea is it's transparent so everyone can see the steps the agency did to try to fill the position, nobody else is available, and it's publicly posted. So if someone has a question later, why is your son, daughter, Hanai, adopted relative working for you? There's a public good cause exception that's available for people to see.
So that was my question. Do you define relative specifically?
There is a definition, and off the cuff, I'm not able to give that to you. I think it's it is clearly spelled out. It's like 2 degrees of again, don't quote me on that, but it is clearly spelled out. It's on our quick guide. It also includes Hanai. So just to be, we're picking up the DLIR's definition of Hanai in that as well. It also includes household member. So if someone lives with you, that also is included.
I have another question. On the slide before for the financial transaction, you mentioned subordinates. That does assume that if your coworkers, it's okay.
There is correct. So some agencies are really large. Department of Education, I think, has over 20,000 employees. There's nothing prohibiting multiple family members working for Department of Education. The key really is looking at supervising, sort of being in a position of power, sort of what classically is thought of as nepotism.
Chair?
Hiring, supervising.
Sorry.
Commissioner.
Can you explain more about the groups that you mentioned that are an exception to the law? And why they are?
Oh, so both the legislative branch and the judicial branch have enacted their own rules on nepotism, and so it is prohibited. But they are self-governing themselves in that.
Sorry.
Mr. Lee.
Were you referring more to like the Aloha United Way and those groups?
No, on the first slide of nepotism, or maybe it was the second, it talked about some groups that accept employees in legislative and judicial branches. Those are the ones I wondered about. But they're those are the ones that are self-governing.
As many of you are familiar, the political process is sausage making. So sometimes laws come out maybe not quite the way I would have drafted it. But again, I feel fairly confident that both branches of the legislature and the judiciary have taken steps to essentially prohibit nepotism. So they have slightly different, restrictions. But this law applies to essentially anyone else. And so that is, the bulk, 95% probably of all state employees.
So just a point of general clarification for all of the ethics rules and regulations, I presume that they apply to, when you talk about employees that are hired on these, on a sole source basis for these 89-day contracts commonly throughout government in Hawaii. I presume all of this applies to them as well.
A large amount applies to them. There's going to be some exceptions, and we'll actually talk about some of those. Like there's post-employment law restrictions, for example. It may not apply to somebody who's only been an 89-day hire. But yes, the definition of state employee is pretty broad. It would even include an intern, for example. And the reason for that is like, for example, we're going to have to cover confidentiality. If an intern comes up and learns something that is confidential, the idea is that those restrictions still apply to them. And, again, if they have a position of power, typically interns aren't quite as high up, but if they have a position where they're making official actions, a lot of these restrictions would still apply to them as well. Okay. So confidential information, what good timing. So this is probably one of the shortest sections, although you see some recurring references to it. Essentially, don't disclose confidential information, and that's a permanent restriction. And don't use it to benefit anyone. Most of what government does is public. It's a public record. A lot of your, essentially all your hearings are public. So you may not be privy to a lot of confidential information, but classic examples might include social security numbers or something else that is privileged and protected. You just wouldn't be allowed to then turn around and use that information to benefit yourselves or to disclose it more broadly. If you have questions about what is confidential, a lot of times we'll actually rely on the agency itself to help define what is confidential, or if it's expressly protected by law, we're going to say, hey, that's just stuff you can't use outside. Okay. Another example might be, for example, if an employee knows access to social media accounts for the government agency and they leave employment, they can't turn around and start using the information they have for their own personal benefit or provide it outside. Just giving you some common examples we've seen. Next. Okay, now we're going to jump into conflicts of interest. This is probably the other large section. And with that, we'll probably be through the meat of the ethics code. Let's go ahead and go to the next slide. So we're going to break this out. But this is probably the one that is the most common conflict of interest section that we talk about, which is disqualifying yourself or not taking official action affecting a business in which you have a financial interest. So let's break what that means out. A financial interest means being an owner, employed, an officer or director, even if you're not receiving any compensation. Let me highlight that one. If you're an officer or director of a nonprofit, for example, lots of people probably in your positions are, right? You're exactly the type of folks people would want on a nonprofit. That is going to be considered a fiduciary duty. You have fiduciary duty as a member of a board or as an officer or director to that nonprofit. You are supposed to keep their financial interests above and beyond your own. And that is going to fit within the definition of a financial interest. You're supposed to help elevate that entity that you're part of. So a lot of people don't necessarily pick up on that, right? Like, I'm not getting paid. No, it's still a financial interest in that entity. Owner of real property, a loan or debt, or a creditor of an insolvent business all meet the definition of what is a financial interest. Any questions on that part?
How about a trustee?
Trustee, yeah, would meet the definition of that.
And a spouse.
We'll get to that
Okay.
just a second. Yeah. Next. So an employee's financial interest, thanks for the leading question, includes a spouse, a civil union partner, or dependent children. And the very first question I usually get is, what's a dependent child? It means for tax purposes, if they're still in your tax filings, that's a dependent child. So again, you can't just look at your financial interest. You also have to talk to your spouse and we've had some unusual circumstances happen. For example, somebody's child, suddenly started volunteering for an entity that somebody regulates. And the person's like, well, wait a second, like I had nothing to do with it. Still would be defined as a conflict of interest, and it'd be something we'd have to work through. Okay. Next. Official action. So what does official action mean? It is a pretty broad term. Essentially, if anybody knows the difference between sort of a ministerial or discretionary, essentially anything that's discretionary is going to fit within the definition of official action. It can include a recommendation. So a lot of times someone will say, well, I don't make the ultimate decision. We'll still ask, did you make a recommendation that someone's going to rely upon? If so, that's an official action. Okay. Next. Sure.
So what would be the penalty if you were to violate one of these sections in the act?
So looking at penalties, there are a couple. One, The Ethics Commission has the ability to issue fines, and we do that in an enforcement proceeding. The fines can go up to $5,000 per violation. So sometimes if there's been multiple actions, it can be a number of violations that have occurred. Even though it's just one entity, you can have multiple situations where something happened. In addition, the agency itself can be ordered to stop if it can't be a part of something that's unethical. So the entire process could be held up as a result of that. In addition, the AG's office has the ability to go and undo actions that were taken unethically. And so it would be an AG decision if it's something that they want to pursue. Classic example might be a contract that was awarded unethically. The AG can actually go in and have that contract undone. Okay. Next. So DHS, or the Department of Housing Services, issues an RFP for a graphic design service. Ken was asked to serve on the evaluation panel. His wife's employer, Noah Design Inc., is one of the bidders. Does he have an issue? Show of hands, yes? Show of hands, no. Okay, thanks. Again, just exploring, it does include spouse, and you may have to have some hard conversations. What are you involved in? What are you doing? I need to know for purposes of this, because I don't want to have a surprise later on in time. And again, having a process, for example, if an entity is coming before you, to have that check-in is a really good idea. I also emphasize, we've talked about, actually, why don't we keep going a little bit? I'm going to do a little bit of a wrap up. Go ahead. Thanks. All right, so there are a couple different sections. We just covered the ones probably the most common. Let me get through these, and I'm going to do a gestalt conversation. You're not allowed to create new conflicts of interest. So if you walked into being a land use commissioner with pre-existing financial interest and involvements of people before you, your obligation is to recuse yourself, and that takes care of it. That's the only thing you have to do. However, once you're in this position, you're not allowed to create a new conflict. So if you believe that an entity is going to come before you and take official, and you're likely to take official action affecting that business, you're not allowed to suddenly acquire a financial interest in that entity. Next. Mari is a director of community outreach and works with several nonprofits as a part of her state job. She'd like to do more volunteer work and was asked by one of the nonprofits to serve on their board. Is that okay? Show of hands, yes? Show of hands, no. So it is a no. And the reason why is serving on the nonprofit, serving on the board, is acquiring a financial interest or fiduciary duty to that nonprofit. And if it's a part of her state job to interact, she's now created herself a conflict of interest. Nothing stopping her from volunteering. That's fine, right? You can do stuff on your outside, but it's creating a financial fiduciary involvement.
So she can volunteer for that nonprofit, but she can't serve on its
Board, correct.
Chair, I have a question.
Commissioner Lee.
Mr. Harris, what if the nonprofit has nothing to do with their state position? Like, for example, we're here and then all of a sudden the Humane Society asks me if I want to join. And I suppose if they're gonna, buy land and develop property maybe, but let's say, until that bridge comes, is that allowed?
Sure. Do you want to go back a slide if you don't mind? So, great question. Thank you. The key is if you have a reason to believe that you will take official action affecting that business, right? So again, you're probably and I think the staff of the Land Use Commission are in a good position probably to help analyze, is it likely that this entity is going to come before you? I mean, if it's known that they're likely to come be involved for some reason, then, we'd say, hey, just, wait until you're done with your service on the Land Use Commission. But if it's, again, somebody who's not doing any land use development whatsoever, then yeah, obviously this would not be applicable. Go ahead and go forward 2, please. Other prohibitions include you are not allowed to assist or represent others for pay in a transaction before your agency on a matter in which you have participated or will participate. So again, if somebody were to ask for your assistance in helping prepare a petition or something before the Land Use Commission, now or in the future, If it's something you've participated in or would participate in, we'd say you can't do that for pay. You probably, it also create some issues if it is something you're going to be deciding, for example, from a Chapter 91 issue. So there's other issues as well. But again, from an ethics code perspective, this would be prohibited. Okay. That might even include, for example, situations where it's not something that come up to the commission itself, but may only be a staff decision. Just how do I help fill this out or whatever it may be. Again, for pay, you wouldn't be allowed to do that. Okay. Greg is a DBED economist who does private consulting work in his spare time. One of his clients asks him for help in applying for a DBED small business loan. Is this okay? Show of hands, yes. Show of hands, no.
Is he being paid for it?
Yeah, again, some of these hypotheticals aren't as great. And every time I do one of these presentations, I always think I have to tighten this up. I think the presumption is it's one of his clients, so it's for pay. And even if he's maybe being paid for other aspects of it, it's still going to be look like you're being paid for this. So we'd say no, can't do it. Okay. So quick summary: disqualify yourself when you have a conflict of interest. Don't create new conflicts of interest for yourself, and don't assist others for pay before your agency. If you don't mind, I'm just going to take a quick second. Many of you are probably familiar with the building code. Building code creates the minimum floor, right? To build something, you have to meet that at least, right? It doesn't stop you from building better. It doesn't stop you from going for LEED or whatever other kind of standards you want to achieve. Similarly here, the ethics code is the baseline, right? But we have a constitutional mandate saying the highest standards of ethical conduct. And so there are many situations where, hey, it may not be a financial involvement, but there may be questions that from a common layperson point of view, people are going to say, hey, that kind of looks like a conflict, even though for purposes of the ethics code, it may not rise to it. I'd encourage you to have that conversation with us, with staff, and talk about it, how to address it. It may be a matter of just putting on the record, for example, as it sounds like it's a standard, and allowing parties to object or not object. Just again, we frequently will give advice on what we call appearances of impropriety, and we'll just make recommendations. Again, if you've met the ethics code, you've met the baseline, that's it. Yeah, you can proceed forward. But our interest, as I said before, is to keep you out of the paper. Our interest is to, just like you don't necessarily want to be in the paper for something. So if there's going to be an appearance, we'll try to help walk through what can we do to help try to resolve that. And again, being able to say that you talk to the ethics commission, you're following their advice, I think does create some level of objectivity, and from a public confidence perspective helps. And so we encourage you to take advantage of that. It is a confidential. We will issue a written summary for you, and it's your ability to do with that written summary as you wish. Okay. All right.
Chair? Question.
Sure.
On conflict of interest and recusals, does the ethics code get into detail about recusals, or is there a standard operating procedure within the state, different boards and commissions as to how, if you recuse yourself, what do you do? Do you leave the room? Do you just be silent? That kind of thing.
Thank you for the question. Again, people can take a more broad version of when to recuse and when they need to recuse. For the ethics code, it's at subsection A, where you have a financial interest in a business, and it might be you, your spouse, or a dependent child, where recusal is mandated. And we essentially say you have to step away from all official action, which would include making recommendations. And so the thing, the most common situation I've seen is someone saying, well, I won't vote, but here's what I think, right? And say, no, you can't do that, right? So I don't think we would obligate you to leave the room per se, but you can't share your opinion or advice or recommendations and try to influence essentially that decision.
If I may, we've been advised by, not up there. We've been advised by our attorney generals that if you recuse yourself, you have to leave the room. I don't know if they've been talking with Robert about that at all, but we've been told.
Yeah, that's why I asked the question, because you get different feedback on this kind of thing. So I wondered if there was a standard that we should all be using.
So let me briefly address that again, sort of in the context of building code. The ethics code in this perspective creates the floor. Your own administrative rules might have a higher threshold, or you may have a practice that's a higher threshold, and that's perfectly fine. And I'd encourage you to follow that. We're just sort of telling you what the bare minimum is required to avoid getting into an enforcement situation. Okay.
I think that's a great idea. So it's 11:20. We'll come back in 5 or 6 minutes. Recess. Okay, it's 11:30. We're going back on the record. Executive Director will join us in progress. There he is. Let's go. Robert, back to you.
So thank you. I think we just have a few more minutes of discussion, and obviously, again, welcome any questions you might have. So let's go ahead and go to the next slide. So there is a provision that applies to state contracts. This is specific to contracts going to a state employee or a legislator. So if it is a non-bid contract valued over $10,000 that's going to a state employee or legislator, it is required that a public notice be given on the Ethics Commission's website before that contract can be awarded. So example might be a school hiring one of its employees to do some type of plumbing or some other type of work in a non-bid contract. This would trigger. And I think the intent really is to make sure there's no impropriety, that it's not a attempt to reward an employee or something, and that's so it gives the public an opportunity to object or be noticed. This doesn't happen very often, to be clear, and I suspect it is a combination of this is not a. It's pretty common. Most things are going to be a bid contract, but also we are trying to make sure people are aware of this provision. Again, that contract could be voided if they don't follow this. So again, it's everybody's interest to try to make sure to follow this. Other state contract provision includes a state agency is barred from contracting with a business that is assisted in the matter by someone who was one, an employee or board member within the past 2 years and worked on the same contract matter as an employee or board member. So an example might be somebody helps prepare the RFP, leaves the agency, and then goes to work for a potential bidder. That company would be barred from being able to apply. And the purpose or the policy for this really is to prevent sort of influence peddling or using some unique knowledge to steer or benefit that company. So pretty severe standard, but hopefully it's a circumstance that doesn't happen too often. Probably the most obvious or sort of common sense approach. We don't want to see potential bidders hiring away state employees in order to try to get in a better position to get that contract. Okay. There are post-employment restrictions, which for 12 months, you are not allowed to represent others as a paid representative before your former agency or division on matters you worked on. There are, next slide. There's an additional restriction which would apply to former legislators and generally sort of the director level or cabinet level from lobbying for 12 months after leaving service. And this is just to prevent sort of that influence peddling, like they know each other kind of circumstance. There's a cooling off period to try to create distance in those relationships. In addition to post-employment, as I said before, on confidential information, just a bar. You're not allowed to ever disclose or use that confidential information you may have gained. I'm pretty sure we're going to talk about an exception in a second, but I wanted to make sure I flagged it for Dan. If there is an exception for, I think you have to have been in service for 90 days, and that will come up in a second. I'll show it to you. So here, Deputy Director Reyna, retired last month, is now working as a workforce consultant. She calls up Senator Tom to discuss a job training bill on behalf of her client. is this okay? Show of hands, yes. Show of hands, no. Okay, thanks. The definition of represent is pretty narrow. It's generally speaking having communication. So it is the picking up the phone and calling that creates the problem. People are not prohibited from going out and getting employment and potentially assisting in behind the scenes. The idea is that just can't communicate with their former officials or former colleagues, or in some situations lobby. So sorry, I said 90 days, it's 6 months. So employment of the state less than 6 months, post-employment does not apply, except for the confidentiality rule. And there is an exception that allows agencies essentially to rehire their own employees. So classic example might be someone's retiring, but they have that unique experience on one project and the agency just wants to have them stay on for a little bit longer to help wrap it up. That's an exception to the post-employment rule. Okay. So talking about penalties, so this is actually out of date. The law just changed as of a couple days ago. It's now up to $5,000 per violation. Typically, everything that happens before the Ethics Commission is then referred back to the agency for potential disciplinary action. And then the state can recover illegal gifts or profits. The state can cancel contracts, license, or permits that were granted as a result of unethical behavior. Let me talk about system enforcement a little bit more. It's probably not the thing that any of us like to do, but we do treat it very seriously. We receive on average about 30 to 40 complaints per month. Many of those complaints are not our jurisdiction, their county, or someone's complaining about their realtor or something that's just not really applicable. But we do a lot of investigations and we have a healthy amount of our staff focused on enforcement. It has been the pattern and practice of our commission to be public about all enforcement actions. Typically, our investigations are all confidential, and that's to protect both the complainant and the individual who's been complained about. It allows us to investigate. If there's nothing there, it can go away and nobody knows about it. But at some point, our enforcement actions do become, if they go far enough, they can become more formal, and they, much like matters before the Land Use Commission, they become a hearing that's visible. Most of our enforcement actions do wind up in settlement, just because it's, yeah, I did it and I don't really want to spend a lot of time, money, and effort trying to defend it. So we try to work something out. And again, those settlements as pattern practice have always been public. So usually it's the idea to give confidence to the public that we're doing our job and we're doing enforcement. Again, let me emphasize, we don't love doing the enforcement. We'd much rather be doing advice. We'd much rather be doing education. So we really encourage you to reach out because we want to avoid this if we can. In addition, people who call for advice that is prospective and they accurately detail the facts and they rely upon that advice cannot have an enforcement action brought against them. So that's sort of another incentive to try to ask for advice. Financial disclosure statements, we January 31st, and employee boards, it's due 30 days of taking office and then May 31st of each year. And then those are filed electronically on our commission's website. My staff, I'm really fortunate. I didn't hire many of them. They all are there and they're all really good. And so if you have questions, hey, I need help, they will walk you through it. And universally, everyone says they do a great job. So please just feel free to say, hey, I need help. Try not to wait till the last day. Try not to wait until after 4:30 because no one's going to pick up the phone. And if you need a extension on filing financial, we can grant one automatically. I think 15 days is an automatic extension. So please just call, talk to us. Try to do it early when not everybody else is also calling at the same time.
So do you know when someone's delinquent and do you notify them?
So we send multiple emails. Sometimes those emails go to spam. So I just warn you, whatever you've registered with us and is a part of our system, we will send you reminders. I think we send at least 4 before the deadline. And then post the deadline, we start sending stuff out too. At some point, we wind up phone calling. And when we phone call, it's probably you're late. And the penalty now is a $50 fine if you have not filed your financial disclosure statement. And then if you don't file it within 30 days after the deadline, it becomes another $250 fine. In addition, we're supposed to issue a press release indicating who hasn't filed. We hate doing that, so we'll do everything we can to try to prevent that from happening. Generally speaking, if you're late, we will do the phone call, and if you file promptly, we don't do a press release on you. Again, the idea is we want the financial disclosure filed. We don't want to fine. We don't want to have to do all that other stuff, because particularly for people who are volunteering on a board, we're sensitive to the fact that, hey, I'm volunteering. Things happen. We encourage you to call us, tell us, get an extension, whatever we can do to try to make sure it works. We want to work with you. But at the end of the day, it is our obligation to make sure these are posted and are public, particularly for this commission. And, at the end of the day, we're going to do what we need to do to get that to happen. Next. So you asked about ways to contact us. This is a screenshot of our website. We try to make it really easy to find the things that you need. So advice, if you click on this button, it's going to give you our phone number, our email address, and a web form. Pick whichever one you want. We have an attorney today. We try to make sure it's practice to get back to you within 24 hours. If it's a really complex issue, we may say, hey, it's going to take us a few more days, but we really try to be as responsive as we can. Again, those requests for advice are confidential as to the person asking. If you're asking about something that's already happened, we'll probably tell you, hey, we can't really do as much to help you. If we can walk you through some remedies, we'll do that. But generally, we want to look at stuff that's coming up. You probably have already seen the file your forms. If you filed your financial disclosure, the purple button, and then the green button for training. And then obviously, if you have a complaint, you can click the yellow button. Next slide. And again, here's also our information. We will provide a PDF of this presentation to Daniel, and he can provide it and make it public for everybody who wants to review it again later. Any questions?
Commissioner Imani.
Hi, thanks. Question on one of your quizzes you had about the graphic designer wife and the husband. Is the solution that the husband pull himself off the evaluation committee, or is the solution that the wife can't bid for the project, or both?
So the state ethics code applies to the state employee. We would not have jurisdiction over the wife per se, or I can't remember which one it was, the person applying for the grant. So the requirement would be for the individual to recuse themselves, and there might be a factual situation of could they recuse themselves just to that one applicant, or do they have to just recuse themselves entirely from the process entirely? Sure.
Thank you. Anybody else?
Let me thank you for your service. I have some understanding of how challenging being on the Land Use Commission is and how much work and time and effort it is. I really appreciate your service. It's because of commissions and boards like this, I think our state government is able to run. I appreciate your commitment to ethics and that highest standard of ethical conduct. It is important that we all try to, from a public point of view, act as ethically and as prudently as we can, because again, it just takes one bad player to sort of cast a shadow on everything else that's going on. It's my sincere belief that 98% of all state employees, both volunteer and paid, are really trying to do their best every day that they show up and really do great work. I think there's 1% of people that sometimes try to push the envelope, like get away with what they can. And then there are some bad apples, and it's our interest to try to catch that, stop it, and prevent it from creating a bad situation. But again, I thank you. Thank you for your time commitment to this. And again, please call if you have questions.
Thank
Thank
you,
you.
Robert. One
Aloha.
last thing, just give us an overview of your commission, how big it is, how many employees you have, what is the reach?
Sure. So we have 5 positions. One's vacant right now. They are for 4-year terms, and it's been pretty traditional that everyone who's been on it has applied for a second term. So generally speaking, they serve for 8 years. Wonderful commission. It is a diverse group of, we have both lawyers and medical professionals and sort of, that the normal range and gamut. We have a total of 12 employees. And, I think we have one of the best agency staffs around. We helped train, for example, 45,000 people last year with 12 staff, no additional budget, no additional employees. We have a number of attorneys, and some of our attorneys have been with us for over 30 years. Just there's a genuine commitment to the cause and a lot of understanding and a lot of good people. So I cannot say enough about how great that staff is.
Great, thank you. Last call for questions? Seeing none, thanks, Robert.
Aloha.
Thanks
Thank
for
you.
sharing your time today. All right. So my understanding is that we will have the Seaworm presentation is scheduled at a specific time. Is that correct? 1 PM. So commissioners, what is your pleasure? We can take a lunch break now and resume at 1 PM. Make sense? Commissioner Lee? Commissioners? Okay, we will recess until 1 PM. Good afternoon, we're back in session. Our fifth order of business today is an informal briefing from the State Commission on Water Resource Management. The informal briefing from the Commission on Water Resource Management Planners is to provide an overview of the State Water Code, Hawaii Revised Statutes, Chapter 174C, which was created by the 1987 Hawaii State Legislature to protect and manage the waters of the state of Hawaii for present and future generations. Ariana, has been any members of the staff who wish to provide testimony on this agenda item?
No, Mr. Chair.
Thank you. Page here. Can I ask the members of the commission from Water Resource Management to introduce themselves individually, and then we'll begin.
Aloha, thank you, Chair. Maybe before I introduce myself, I'll pass it over to staff who have joined us today from the commission. Alexa,
Sure.
I'm sorry.
Have to use the microphone.
Aloha Commissioners, Alexa Dyker. I'm the legal fellow for the Water Commission for about 3 years now. I'm a Richardson grad.
Thank you.
Aloha, I'm Bonnie Lu, Secretary for Planning Branch of the Commission on Water Resource Management. Thank you.
Aloha, Maika Ko. My name is Liz. I'm a hydrologist in the planning branch.
Hi, I'm Nicholas Singh, a planner with Planning Branch.
Aloha, Chair, Commission members, Neil Fuji, also in the planning branch. Thank you. Thanks for having us.
Thank you.
All right. And my name is Katie Roth. I'm the planning program manager with the Commission on Water Resource Management. Thank you again for inviting us today to share a bit more about our agency and what we do.
So just a second before you begin, I'd like to welcome Arialis and our colleagues from OPSD. So are you going to be testifying today, or are you just here to listen? Okay, glad to see all of you. Thank you for coming. So can you give us a general idea before you begin of about how long your presentation is?
Sure. We have estimated or planned for about 20 to 30 minutes for our presentation with an opportunity for questions at the end.
Okay, and you prefer that we hold questions to the end?
Actually, we're happy to field questions as we go through the presentation. We thought we could keep it somewhat informal and let you ask questions as we go along, since there's definitely a lot of information to cover and some of it might be new.
Yeah, I think that keeping it informal, and if there's even points of clarification or confusion, if you don't mind us interrupting and getting that straightened out as we go.
Absolutely.
Okay, so proceed.
All right, thank you. So again, Katie Roth with the planning program at the Commission on Water Resource Management. Again, we have staff here from the planning branch, but as you'll see in my presentation, we have a few more staff that aren't represented here today. That includes a couple other branch chiefs and our acting deputy director, who unfortunately couldn't be here today. Several of them are on vacation. So again, today I'm going to present more information about the Commission on Water Resource Management. I guess I have to scroll. Okay. This is a little presentation overview about the different topics I'm hoping to touch on today. Again, who we are. I think most of you are familiar with the name, but you may not be intimately familiar with all the work that we do. So I'll give a little bit of more information about the various programs under the commission. Alexa is going to do more of a deep dive into water law in Hawaii, including our water management and permitting processes. I'm going to talk a bit more about the Hawaii Water Plan and how that intersects with land use planning, as well as touch on current engagement that our office and agency has with the Land Use Commission and potential opportunities for improvement. All right, who is the Water Commission? So in 1978, during the Constitutional Convention, there were amendments to Hawaii's constitution. One of those amendments was to mandate and establish a water resource agency within the state of Hawaii. That agency is what came to be known as the Commission on Water Resource Management, but it took about 10 years before we were actually established. We're administratively attached to the Department of Land and Natural Resources. The staff you see here today, as well as others with the commission, are all based here on Oahu, but our mission and mandate is statewide. So we have staff in addition to a 7-member commission, and I have more information about the commissioners, who they are, on a future slide. We are the primary guardian of the public trust. So we are essentially the trustee of water. It's our role within the state to protect the resource and manage it properly. We have a dual mandate of both protection of specific uses of water as well as to provide for maximum reasonable and beneficial use. Sometimes those mandates do come into conflict, and we'll talk a bit more about that in some later slides. We administer the State Water Code, Hawaii Revised Statutes 174C, and we regulate all waters of the state, so ground and surface water. Groundwater is our aquifers, surface water refers to rivers and streams. We do not regulate coastal waters, and we also regulate all water users, including the counties. So if the county wants to drill a well, they would come to us for a permit to drill that well. We also primarily manage and deal with issues of water quantity, not quality. Quality issues tend to be under the jurisdiction of the Department of Health, but we know that water quantity and quality issues are interrelated, so we view the Department of Health as a co-trustee of water, and we try to work intimately with them on a variety of issues. The pictures along the bottom represent the current makeup of our 7-member commission. In our statute, it identifies who should sit on the commission. That includes the chairperson of the Board of Land and Natural Resources, or the director of the Department of Land and Natural Resources. At the moment, that is Don Chang. Also, the director of health is considered an ex officio voting member. DOH has a designee, Kathleen Ho, who currently sits on the commission. We also, all of the other 5 members must have substantial experience in the area of water resource management. They are all appointed by the governor and approved by the Senate. You can see we have a question mark there at the end. We have 1 vacancy currently on the commission, and that is the member that needs to have substantial experience and expertise in traditional Hawaiian water resource management. So that seat is currently vacant, and we're hoping that it gets filled soon. Here's another overview of our mission, what our vision is. This is really just to illustrate how broad and expansive it is. There's a lot we are responsible for and have a mandate to do, but due to limited budgets and staffing, obviously we can't do all those things. But I just wanted to paint the picture for you that we are responsible for a lot, and it's a very broad mission and mandate that we have. Oops. Sorry about that. Here's more of an organizational chart describing the programs that are under the commission. I'll go into more detail in a future slide. Currently, we have 28 positions within the commission. We're in the process of trying to fill another 4 or 6 that were recently authorized by the legislature. Of those 28 positions, they're all based here on Oahu, as I mentioned, but we do extensive travel to the neighbor islands to conduct various community meetings, outreach, data collection, things like that. The budget that we have currently is approximately $4 million a year. That's our operating budget. Most of that gets eaten up by personnel costs. About $1 million of that gets eaten up by an agreement we have with the U.S. Geological Survey, and they assist us with various monitoring and data collection efforts. We also have a fairly small budget for capital improvement project money. That's money that we use to develop our deep monitor wells, and I'll talk a bit more about that later. So again, the 4 programs within the commission are the survey branch, planning branch, which I am the head of, groundwater regulation, and our stream protection and management branch, or we call them SPAM for short. So here's an overview of those various programs. Planning, we are responsible for developing long-range plans for the protection of the resource. I'll talk more about that again in a later slide. Groundwater regulation issues various groundwater permits. They monitor aquifer health. They establish sustainable yields. Streamwater protection and management also issue permits, but related specifically to surface water. They're responsible for establishing interim in-stream flow standards. They also do a lot of data collection and hydrologic monitoring of our streams and surface water systems.
One quick question. When you say a permit, is that synonymous or really different than an allocation?
It depends. So we have water use permits, which we will talk about later. Alexa will go into more detail on that. Those are associated with a specific allocation of water, and those are only issued in designated water management areas, which we'll again talk about more later. We also have like wall construction permits, stream diversion work permits, which we consider to be more ministerial. Those permits aren't taken before our commission, and those do not have a specific allocation associated with them.
That's very helpful. Thank you.
We also have our survey branch, and they're responsible for collecting and analyzing various hydrologic data that helps us determine the health and viability of the resource. Along the side here, you'll see various logos from different agencies and partners. I wanted to illustrate that even though we are the primary trustee of water, we can't do this work alone, and we rely on a variety of other agencies and water resource management organizations to assist us. The Division of Forestry and Wildlife, as you may know, is responsible for Malco watershed protection, native ecosystem protection, forest protection. We don't have water if we don't have healthy forests, so we look to them to do a lot of that work, which we obviously can't do given our limited budget and staffing. We have the Department of Health, which I mentioned is a co-trustee of water, primarily responsible for quantity or quality issues. USGS assists us with various studies, hydrologic monitoring, data collection. We pay them to do stream flow assessments, seepage runs, things like that to help us have a better understanding about the resource and what's going on. Division of Aquatic Resources, they manage nearshore waters, more of aquatic coastal ecosystems and habitats. There's a lot of unknowns as it relates to wells that are drilled near the coastline and how those may impact these sensitive habitats and environments. So we work with DAR to try to better understand impacts of water use on those systems. University of Hawaii, they have a water resource research center that we collaborate with regularly, again, on a variety of more studies and research-related inquiries. And then Ahamoku, anytime that we are reviewing a permit or having to make decisions about water resource allocations, we typically will route submittals and projects over to them for review so that we understand what the implications are of that project, of that water use on traditional and customary practices. Planning branch, we implement the state water code through these long-range plans. We're also engaged in a lot of the community outreach efforts. Agency coordination, again, is a big deal. We're typically the ones reaching out to the different agencies and water resource managers to better understand work that they're doing and how that may dovetail with initiatives that we have going on at the commission. We develop and update the Hawaii Water Plan, which I will talk more about later. The Hawaii Water Plan is essentially supposed to be our guide for how we manage and protect the resource. That also involves county water use and development plans, which has a land use component to it. So I'll talk about that. Planning branch is also responsible for developing water conservation, water shortage, and drought plans as well. Groundwater regulation, throughout the state, we have identified different aquifer system areas, which you can see outlined here in the map of Molokai. Each aquifer has what we call a sustainable yield, or the amount of water that can be sustainably withdrawn without impacting the integrity of the resource. Statewide, we have over 5,000 wells, all permitted within our agency. On Oahu, over 2,000 of those are just based here on the island of Oahu. Statewide, we have 110 aquifer system areas. So again, this is to illustrate there's a huge amount of area in terms of land that we're responsible for and all the aquifers of the state that we have to manage and monitor. Stream protection and management. This map of Kauai is to show you all the different perennial streams. You can see here in blue, the black dots are known diversions. A lot of those are historic diversions from the days of sugar and plantations. We're still dealing with the repercussions of a lot of those plantations, ceasing to exist, and what that infrastructure, does today, how we manage the resources where water is still being conveyed outside of watersheds. Statewide, we have about 1,300 diversions, and we're often responsible for looking and reviewing at permits that may seek to make changes to those historic diversion systems. Oftentimes, it's removal of those diversions to allow stream flow to flow again. The branch of the commission, the span branch of the commission, is responsible for establishing those interim in-stream flow standards. So that's the amount of water that we need to keep in a stream to provide for a variety of in-stream as well as off-stream uses. So that's been a big initiative within the last 10 years, is to establish more in-stream flow standards statewide. At the time of our inception, in the 90s, basically we'd said that the in-stream flow standards for all streams was status quo. So even if there were diversions happening or there was no water flowing in the stream, we just said that's the status quo. The Supreme Court has since told us that that's not acceptable and that we need to actually go through an analysis process and investigate how much water should be returned to streams to, again, meet those in-stream flow standards.
Is that the decision that just came down?
No, it's not. Well, that is related, but the initial decision from the courts that said we could not continue to operate under the status quo is from decades ago, I think.
Yeah.
Under Waiahole, I believe.
But it was refined and somewhat. You could explain that to us if you get it, if you can at the right time.
We can take that opportunity now.
Okay.
Do you want? It's better. Okay, we'll do it later.
Okay, we'll wait.
Thanks.
That'd be great.
Again, our stream protection management branch does do a lot of data collection, hydrologic monitoring of stream systems. This is to illustrate how many monitoring sites we have across the state. Our stream protection and management branch chief, acting branch chief, Aaron, many of you may know him or have seen him, Aaron Strauk. He's constantly traveling to do a lot of this data collection. He's in the field constantly with his team. But as much as he's in the field, we still need more data collection. So that's where the USGS comes in. And again, we pay them about $1 million a year to assist us with the data collection work that's needed. Survey branch, I mentioned that they are also responsible for data collection and monitoring for a variety of reasons, mostly because there's only one staffer currently in that program. They primarily focus on groundwater data collection and monitoring, so they're not involved in stream monitoring at the moment. They visit, we did have two people, now there's just one. So he visits the different deep monitor well sites we have across the state. Currently, we only have, this is 12, but I believe it's 13. Ideally, we need more deep monitoring wells. These are the wells that penetrate through the freshwater, through the transition zone into the saltwater. You can see here in this graphic. These are the wells that we use to assess and ascertain the health of our aquifer systems. helps us with this to understand, if we're pulling too much out of the aquifer or what needs to be done in terms of policy changes and better regulation. The CIP money that I mentioned again is paying for the construction of new deep monitor wells. The $2 million a year, though, is getting us approximately one new well. So these are very expensive projects to undertake. And here's a map of those deep monitor well sites. The seaworm sites are in white and those under construction are in yellow. Again, that adds up to about 13. The black dots indicate where there are other monitoring wells that are not seaworm wells. Some of them are USGS wells, some of them are county departments of water supply. But we try to engage as much as possible in information sharing. So the data collected by the counties should be and is being shared with our agency for analysis.
Chair,
Where's that from?
excuse me, I just, before
Please do.
there's so much information, I don't
Absolutely.
want to
Commissioner Garsman,
forget
please.
my thoughts. Can you go back a slide?
Sure.
Thanks. So it says ideally there should be 3 deep monitoring wells in each aquifer system.
Yes.
Doesn't it depend on what the aquifer composition is, or is that really just a?
Well, given that these wells are helping us better understand resource health and availability, unfortunately, we don't have as much information as we need to fully understand what areas may be threatened. We do get water use reports and we have sustainable yield information, but it's these wells and the data we collect from them that really helps us better understand what's happening with the resource. You're right, though, that there is different geography on each island. This is, a kind of a blanket statement about how many ideally we would want. But yeah, the placement of those wells varies, and the cost of them varies as well, depending on the location and depth that we have to drill.
Can you tell me where the 2 on Hawaii Island are, please?
I'll go back to the map.
Thank you.
Yes, so we have 2 south of, I guess that north of Kona. I think that's Koloko, Neil. What's the other one?
Keoho?
It's in the Keoho Aquifer. Yeah, and then we're also drilling one up north at Hapuna State Park. So that is a project currently in process at the moment.
Thank you.
Water resource reporting, anyone who gets a permit from us has to report monthly on their water use. Compliance in that area is improving, but it's definitely something that is not consistent across the board. We have pretty good compliance when it comes to our groundwater reporting. Surface water is in some cases much harder to do, and therefore we have less data that's coming into us. But this slide is just to let you know that everyone is required to report per our admin rules. We need all the data in order to understand, again, resource availability, how to make informed policy and management decisions. We have a couple vacant positions I mentioned that would focus on enforcement. So we're hoping to get those filled, and then we could actually get people going out into the field to investigate and work with water users to, understand what the issues are with the lack of reporting. But that's something that's in process at the moment. And with that, I will hand it over to Alexa.
Let's take a second. Let me see if there's any questions on your part of it. Anybody? Any further questions? I got a couple.
Sure.
When you use the word diversion, do you differentiate between a stream diversion that it's diverted and then it has a use and it's diverted back into the stream?
I guess I'd have to refer to possibly our statute or admin rules for the specific definition of a diversion. But in my understanding, it's the physical infrastructure that's taking water out of a stream and diverting it. So I think it could relate to water that's taken out of the stream, but then is returned eventually. Yeah. Go ahead.
Sorry. Oh, we got another one coming your way.
Thank you.
Oh, here we go. Now you got all kinds.
Yeah. It would refer to the,
Speak right into the mic.
sorry. Yeah, the version was referring to, the point in the stream where water is withdrawn from the stream, whether or not it goes back.
So whether or not it goes back, it
Oh.
doesn't, you don't make
Yep.
a difference.
Yeah, could be consumptive, could be non-consumptive, like loikalo, where it's returned to the stream at some point. But regardless of what happens, it's where the point of removal of the water from the stream.
Chair, to add to that, I think it depends on the context. So we are accounting for if water is being returned to the stream, but that would be in a different, so if you give us a little more context. For your
Context
question.
would be if it's diverted out for a farm and it used to raise agricultural crops versus diverted into a hydroelectric plant and then returned back to the stream. Those to me in my engineering mind are very different mechanisms, designs, and measures of water use. So I just wondered if you distinguish between the two.
We do. And what you're describing is if it's being returned to the stream would be like, if it's like an in-stream use. So your example was a hydroelectric plant, but like our example that we are encountering more often is loikalo for like traditional customary. They're diverting water into their lo'i and then returning it back to the stream. This would be a similar in-stream use. So
I think you just hit on it, which is diversion means it comes out, doesn't come back, but in stream use, it can be circuit.
yeah, so we are differentiating between off-stream and in-stream uses.
That's
And that
helpful.
would be in the context when the commission is setting interim in-stream flow standards. That's why we're accounting for it, absent water use permits.
Very good. That answers my question. I'll hold my other question. So go ahead.
Chair, I have a stream question. Is now the time?
Sure, we'll see if we can answer it.
Okay, thank you. Aaron did come to Waimea on Hawaii Island not that long ago, and the audience had a lot of different feelings about what should happen with the streams that go through Waimea and down to the ocean. And some seem to think that the water should just flow, and others think that it should be used upstream because when it just flows, it ends up in the ocean. And it's really causing a lot of issues to our reef and the fish. My husband and I go swim every weekend down at Wailea Bay, and it's been really bad this year because of the storms we had and the runoff. So what is the commission's view on the stream water affecting coral reefs, for example?
I think the nature of streams in Hawaii is that they're really flashy. So what you're describing is more like a flash flood event when we have high rain events. Of course, the commission is very cognizant of like impacts on nearshore environments, coral reefs, and that hence we are working very closely with DARB, the Division of Aquatic Resources. But also for native wildlife or fish life, we need water to be flowing into the stream. So, and when I'm going into our public trust uses of water, this will be explained as well. So like stream flow, like Mauka to Makai flow is actually one of the 4 public trust uses. I hear your concern, and we are also concerned from the runoff events. But those would be actually different infrastructure solutions that would have to be found, which are actually not seaworm. That would be our engineering division. We're managing flood infrastructure, or the Army Corps of Engineers.
I could just add to that as well. So we have the Division of Forestry and Wildlife was responsible for Mauka watershed protection, forest protection, and that does play a role in, incidences of erosion, sedimentation issues, what we're seeing, the impacts of sedimentation on coral reefs and nearshore waters. So in our work in, studying interim in-stream flow, in our work in establishing or reestablishing stream flow, we do want to try to make those decisions in coordination with agencies like DOFA and understanding what projects or initiatives they may have happening within the watershed, whether that's invasive species removal of animals, reforestation efforts, fencing efforts, all of those things that kind of keep soil on the landscape can also play a factor in that.
So I proceed with water law in Hawaii.
So please speak, state your name
Um,
again, if you don't mind, and then speak, see what I'm doing, speaking right into the microphone.
Um,
Unfortunately, that's what
Thank you, Chair. My name is Alexa Daika. I'm the Legal Fellow for the Water Commission, and I will be presenting on water law in Hawaii for you today. So Hawaii water law relating to freshwater use and management is grounded primarily in the Constitution, the Water Code, as Katie mentioned, Chapter 174C, and the administrative rules for seaworm, and court decisions interpreting these and other relevant laws. So on the left side of the slide shows the hierarchy of these laws, with the Constitution being on top. The court decisions listed here are all Hawaii Supreme Court decisions pertaining to water. The decisions marked with an asterisk are by agencies other than seaworm. So the first example is Kauai Springs dealt with a water bottling application before the Kauai County Planning Commission. In the Lanines case, I'm not sure how many of you are familiar with it or were in the LUC at that time, is a case before the LUC. Besides those two cases, the Hawaii Supreme Court overturned the agency decision, seaworm's decision, and remanded. I have included a citation for each of those cases in case you wanted to look up for your personal reading pleasure, the whole opinion. The latest case, Nawaiha 2, that's just a short form. The proper title is a longer title, was just decided about 3 weeks ago and does not have a citation yet. In the following slides, words preceded by quotation marks, and in italics are direct citations from these Hawaii Supreme Court decisions. Next slide. Article 11, Section 1 of the Hawaii Constitution establishes that all public natural resources are held in trust by the state for the benefit of the people. And Article 11, Section 7 specifically references water, includes the directive to protect, control, and regulate the use of Hawaii's water resources for the benefit of its people. It's important to note here that in Hawaii, there is no ownership of water, and water is held in trust. Although other county, state, and federal agencies may have overlapping jurisdiction in some areas, seaworm has the primary authority and is a primary guardian over freshwater use and management. These constitutional mandates and duties do apply to other state and county agencies. So whatever we are mandated as the primary guardian, it also applies to the LUC or the PUC and the counties as well. So seaworm is tasked with many duties, including establishing water conservation, quality and use policies, defining reasonable beneficial uses, protecting ground and surface water, and regulating Hawaii's water resources while assuring pertinent rights and existing riparian and correlative uses. So with those amendments in Article 11, Section 1 and 7, the Hawaii Supreme Court stated the people of Hawaii have elevated the public trust doctrine to the level of a constitutional mandate. So pursuant to the Constitution, the Water Code, and common law, the State Water Resource Trust applies to all water resources without any exception and distinction. The court then further held in Waiahole 1, this is our seminal case from the year 2000, that the public trust imposes a dual mandate of first protection and maximum reasonable and beneficial use, which then establishes an affirmative duty to take the public trust into account in the planning and allocation of water resources and to protect the public trust uses whenever feasible. Next slide.
Just a quick question.
Absolutely.
You didn't mention federal. So does your jurisdiction extend over to federally owned land and federally owned enterprise?
Yes.
Thank
So this slide deals with the first prong of the dual mandate, protection, and listed here are the public trust purposes or uses, and the terminology is like used interchangeably. So the Supreme Court has identified 4 public trust purposes. The first one is environmental protection, that's
maintenance of water in its natural state. That would relate back to Commissioner Carr's question on like stream water.
Ariana, we lost the mic.
Waters.
There you go. You're
Okay.
back.
Water remaining in the stream. The second public trust purpose is the exercise of traditional and customary Native Hawaiian rights. Then we have domestic water uses, and the Supreme Court in Waiola from the Molokai case added DHHL reservations as a public trust purpose as well. And it's important to point out here that there's no absolute priority between those public trust purposes, so they're all equally important. The slide deals with the second prong of the dual mandate, the maximum reasonable and beneficial use. So when you just look at the plain language of the water code, you have the definition in section 3. This is on the left-hand side. But the Hawaii Supreme Court has clarified that when you're interpreting the code, you will always have to use the lens of the constitutional mandate and duties. So when we're looking at if a use is reasonable and beneficial, we have to at least at minimum use those other three requirements that are listed here. So the applicant has to show their actual water needs, then make sure it's the propriety to drain water from the streams, for example, and also have an absence of an alternative that they could use. Next slide. So under the public trust, any balancing that CWOM or any agency, LUC, PUSC, the county would have to do always begins with a presumption in favor of the public trust. For the public use, access, and enjoyment, the public trust also prescribes a higher level of scrutiny for private commercial uses. So therefore, CWOM must closely examine any request to use public resources for private gain to ensure that the public interest in the resource is fully protected. So additionally, permit applicants have the burden of justifying that their proposed uses in the light of protected public rights and the resource are protected. Next slide. So I added this in because this comes from the latest decision from 3 weeks ago. And this slide highlights the additional fundamental principles of the Water Resource Public Trust. Those are direct quotes from the Supreme Court opinion. And as the court already has held in Waiahole 1 in 2000, that there can be no automatic vested rights to water for any person or entity. And I think this is really important in the context of how CWARMs and LUC regulation interplay. Because even if a development receives all entitlements of the LUC or the county, it is not guaranteed that this entity or development will later on receive the requested or needed amount of water when there might be a detriment to the public trust.
So where does that get adjudicated?
Can you repeat your question?
If that example, hypothetical, where they got everything in line and yet they don't have the water allocation because there's a question that it might be in conflict as defined by this ruling, where does that become adjudicated or addressed?
I think, Chair, I will use this example again later on in the slide because we have different types of regulation of water use depending on the areas of the state. And
I'll wait for you.
Okay, so I'll bring it up there again and then we can play through the different scenarios. Next slide. So in addition to the public trust, the Hawaii Supreme Court also adopted the precautionary principle, ruling that the lack of full scientific certainty should not be a basis for postponing effective measures to prevent environmental degradation, and that where there's scientific uncertainty exists, a trustee's duty to protect the resource mitigates in favor of choosing presumptions that also protect the resource. So basically saying when in doubt, protect the resource. Next slide. So I included this slide because in one of those Supreme Court opinions, the court was so nice and gave you a cheat sheet. So the 6 principles as a decision maker that you have to fulfill to fulfill your duties under the public trust. And next slide. The next slide shows the 4 affirmative showings that the applicant needs to make to also, you need to, as a decision maker, you need to check is the applicant fulfilling the burden here. And we're moving on to water management and permitting, what everyone has been waiting for. So here we are. So this slide shows CWRM's jurisdiction. As mentioned earlier by Katie, CWRM regulates all water of the state, excluding coastal waters and all water users, including the county water boards and department. So the map shows the water management areas in the state. And as of 2024, all of Oahu except Waianae and the island of Molokai, Iao Aquifer on Maui, and Lahaina Aquifer sector are designated groundwater management areas. Currently, there are no groundwater management areas on Lanai, Kauai, or Niihau and Hawaii Island. Although in February 2017, the Water Commission denied a petition to designate the Keowau Aquifer as a groundwater management area. And the most recent, in August 2022, the Commission designated the Lahaina Aquifer sector area as both a ground and surface water management area. So that's what you see in blue highlighted in the excerpt of the map. This is the area where we have ground and surface water management areas, and also Nawaiha is a surface water management area. The next slide. So when is an area designated? So the commission shall designate an area when it's threatened or endangered to become, that the water resources are threatened to become endangered. So we have, there's processes. So either it can be done by petition, or the chairperson can also initiate designation proceedings. The code establishes different criteria. When an area needs to be designated, there's 3 surface water criteria, 6 groundwater criteria. For example, if you have diminishing water levels, serious conflicts, saltwater intrusion, water quality degradation, and most importantly, when we're approaching 9% of the sustainable yield. Also, as a background information, so water management area designation is nothing new. That already preceded the code from before 1987. And originally, the water code was intended to have this regime of water use permits statewide, but it was a political compromise for the code to pass in 87 that it would be like a phase-in approach. So the areas that you saw on the slide before, over the years, have become water management areas. So next slide.
And maybe I'll just add that that doesn't mean that new areas couldn't become designated. And again, that's a process of us understanding resource availability, having all the data to understand what's happening and whether or not we actually need to designate.
I think this is the slide Chair was waiting for. So to recap, CWRM regulates all waters and all water users. However, CWRM does not regulate all water use. So Hawaii has a bifurcated system only in the water management areas, the areas that you saw on the map earlier. CWRM will require a water use permit where we're setting limits on the amount of water that can be used. In the rest of the state, we are not per se setting limits of how much water you can use. But even though the common law applies, CWRM is still bound to use it, like fulfill its public trust duties, which means then, for example, just because you operate a stream diversion doesn't mean that you can take the whole stream. So we're setting the inter and in-stream flow standards at the amount that have to stay in the stream. This would be an example of that. Also want to note there's a third type of regulated water use. Only have it small on the slide with an asterisk, because if you're trying to take water from state lands or drill a well on state land, you would need a water lease. But that's not under CWRM jurisdiction. That's the Board of Land and Natural Resources that are responsible for that. So I think the easiest way to visualize this in Hawaii is like the way we're regulating water use. It's not like we have one law for all water use. It's like whatever land the water is falling on, this is the set of laws that we're going to apply. Next slide. So those are the permits that Katie mentioned earlier. So all of these permits are applicable statewide. And I want to make a little correction. Those are not ministerial. They actually do come before the commission, with the exception of a few well construction permits that have been delegated to the chairperson. All the other ones do come before the commission. But those are very different than water use permits, because here for these permits, those are technically construction permits and they expire after 2 years. Next slide.
So water use permits, on the other hand, are only required in water management areas. So after an area is designated, as you've seen in Lahaina, all existing users have 1 year to apply for a new water use permit to continue their water use. And water use permits do not have a time limit. So, which means they can, but they can be revoked if someone isn't using their water use permit for 4 years. So it can be a total non-use or a partial non-use. However, CMOM is required to review all water use permits every 20 years. It is also important to note that if you're applying for a water use permit, you may also still need to come in if it's not an existing infrastructure. If you need to drill a new well, then we also have to get a well construction permit or a stream diversion works permit.
So this, I don't know what to call it, but these set of rules came before us in a very recent case having to do with new development on West Maui. And I'd like, if you don't mind, to elaborate on the current state because we were confused, which is existing water users have 1 year to reapply or apply to secure their original or some form of water use permit. And that anybody else that never had water before has to wait until that process is completely finished and cannot even apply. Is that, can you expand upon what reality is?
I can expand on that, and I mean, this may have been a process how we have handled permits prior, but especially in the case of Nawaiha, we have taken existing and new use permits at the same time. And the latest ruling of the court also makes it very clear that CIROM can take existing and new uses at the same time. I assume you're referring to the Pu'ukuli'i development that came before
There were
you.
a couple.
Yeah, a couple. So the water purveyor for those potential water purveyor for those developments could come in at this time to us with a new use permit. But CIROM just did not receive for those specific. I think what I have in what we've noted before that Pu'ukuli'i was one, or Kanapali 2020. We have not received a water use permit application for a new use for those. But if those purveyors were to send us a permit at this point, we can take it at the same time as we're taking the existing use permits.
So is there any sense of, so I understand they could submit an application. Is there internally within CWORM, is there any sense of priority established in addressing those applications, whether it's for an existing use or for a new use?
The way we are going to tackle all the water use permits in the Lahaina Aqua sector area was that we're going region by region. And our intent is to start with the region where those particular developments are actually located in the Honokowai Aquifer. So we have already reviewed all the existing use permits, and there's one new use permit as well. And if we were to get a new use permit at this time, we would address them at the same time. Because as I pointed out in one slide from the Nawaiha latest decision, just because you have an existing use doesn't mean that you will actually get that amount again. Because if it's not reasonable beneficial, you will not get the same amount. And from the first glance at the applications, we definitely have some concerns about some uses in the area that we have to ensure that they're reasonable beneficial and that we're not wasting water.
Yeah, that sounds very reasonable approach. My concern in the genesis of my question was whether or not they would get attention, whether it would get reviewed in a timely way, new versus existing. And what I'm hearing you say is that they're all in there together and they're being evaluated collectively. Is that a fair statement?
That is a fair statement. I mean, I can't speak for the council that would be advising the applicants at that time.
Sure.
Because for Honokowai Aquifer, for example, is the reason why we designated the area is because we are already over sustainable yield. We had the documentation from the Department of Health that we have water quality issues, we have saltwater intrusion in that area too, because they have legacy contamination from plantations. So the existing wells have to treat their groundwater to make it drinkable. So there's a lot of issues in the areas already, and have reservations for the Department of Hawaiian Homelands, which is a public trust use. So yes, it will be difficult for new use applications to fit in, but depending on what the commission will decide, what is reasonable, beneficial, if the existing uses as, if I'm just using some numbers, if there's the applicant is asking for 4 million gallons a day, but the commission will determine that only 3 million gallons a day are actually reasonably beneficial. This would free up 1 million gallons for a new user, for example. So that's how we are going to approach this and look at this issue.
Okay, that's very helpful. So if a developer comes in front of this commission and says, I've got everything done, I'm just waiting for my water allocation, and Seaworm will not even accept a permit application, we can say on the record that we've heard directly that that's not the case, that you can, that you will in fact at least accept an application for a
Yes.
new use.
Yes, we can guarantee that if all the existing reasonable beneficial uses are provided for, that there will be water left. We
Yeah,
can't guarantee
with
that,
those
but
caveats,
if
yeah.
there is, we will address new use applications.
Okay,
as we
thank
can.
you. Question, Commissioner Wu.
Quick question. What would be the timeline? Say if you make that decision that there is adequate water available for new use, is there a potential time period of, I'm just trying to figure out, we lacking serious housing on Maui pre-fire, right? Is there anything we can do to help aid our island back in building, whether it be existing uses or new uses? Is anything Serum is doing to help to bring us back to some normalcy? Is there a process? I know it can be very confusing for someone like myself, layman's terms in understanding the water issues, but I understand that cane was very thirsty, sugar cane, and there is none sugarcane. I understand that we need stream flow, but to what cost at housing? Maybe what will be the, you guys said prior, there's no priority in housing, but I know stream flow. I know people that Lo'i patches, Lo'i farms, they have a lot of water being discharged into the ocean, kind of like what Commissioner Carr Smith brought up. And how does that equate to not having housing? So I'm just trying to figure out how we balance bringing some housing back, because everybody's looking for this answer on Maui, and everyone on all islands, and everyone is saying seriously, it's CWRM or it's Land Use Commission, and now I'm joining the crowd, right? But how can we assure our own people on our own island? Like what it said prior, I'm going all over the place, don't get me wrong, that you are the guardians of public trust, but also at the same time to protect and manage for present and future generations. And just to let you guys know, we leaving, our people leaving. So I want to understand how we can accommodate to keep our people on Maui. Again, go be with housing, go be with water. Is anything available? And I understand that your job is to balance that, right? And I see a lot of stream use going in the ocean, which is fine, but I don't see that equating towards housing, or how we could use it to housing, or how we can utilize different waters, be it off the injection wells, whatever we need to come up with some solutions. I think everyone on Maui is waiting for a few solutions and some guidance. And I watched the meeting. This is my first meeting, so sorry. I watched the last meeting. There is a lot of confusion from Kaanapali land, what they said, and being what's heard here. It's a major confusion. It's like totally different people talking out of different. It's like we're not even in the same page for sure. How can we correct that? Sorry, that was like 10 questions in one, but I'm confused, and I hope you can give me some peace of mind to give me, there's a light at the end of the tunnel for Maui. I'm hoping for something from you guys.
Mahalo, Commissioner U'u. I appreciate your question and I share your concern. I think Maui is Maui is a great example, and it's very specific which area you're looking at. If you're looking at East Maui, when you're like the closure of A&P HCNS, or if you're looking at West Maui, where Pioneer Mill actually closed in 1999. The shortage of water, no, shortage would be too harsh of a statement, but like threatened water resources in the Lahaina area, that is something that was actually on the radar already like in the late 70s. And then we avoided this type of designation early on, where we could have gotten a handle of this earlier. But I appreciate that you're bringing up alternative water sources, because I think that was the impetus of the Water Commission as well, when we designated this area to have administrative control, because only when we require water use permits, we can require a user to use an alternative source, which would be the R1, the injection wells. So Honokowai, for example, where we're already over sustainable yield, we're using groundwater to water golf courses as well, or we're using groundwater to irrigate landscaping of hotels or luxury homes. If we could substitute those irrigation needs with R1 water, we would free up water that could go towards housing developments. I'm hoping that gives you a little peace of mind. But the other missing piece, which is not CWAM's Kuleana in a sense, is water source development. And that is, I'm using Maui as an example. So Maui County has not developed many new sources. And Maui County traditionally was always very dependent on the plantation systems. So Maui County, compared to other islands, is way more dependent on surface water for drinking water to treat surface water. So you have that from the EMI system, that surface water is being treated and goes to upcountry. You have the same in Lahaina. So actually, we are still allowing, at this point, allowing Maui County to completely dewater a stream to use for drinking water in Lahaina. Then we have water out of Honokohau, which is also being treated to become drinking water for the county. And that's why you have, but then on the west side of Maui and Lahaina, you have the county as a water purveyor and multiple other private water purveyors who have access to groundwater wells, which the county doesn't, to a limited degree only has. And with climate change, the conditions are getting just more dire, because we have diminishing rainfall, we have diminishing stream flow. So when your drinking water supply is dependent on stream water and we have less stream water, we are going to run into trouble. We have to really look into how can we make sure for future generations that we have enough groundwater as well, that we're not taking too much groundwater, because if you're taking too much groundwater, salt water will come up. So that's what we are trying to accomplish here.
Thank you. And I have rumors there's a proclamation coming out for the county to work with private landowners, purveyors, as you said, to take or lessen the injection wells, and again utilize some of the waters for better use. You guys would support something like that with Serum, or you guys would stay out of that? Is that a possibility of some support that you guys might show to help? I would say expedite that process of asking the county to partner with private water owners. Is that something you guys do, or there's something the county will do and they'll come back and see you guys to I guess initiate the process?
Commissioner Wu, I think you mixed a couple of questions in one again.
Okay.
So I think I'm not quite sure what proclamation you're referring to, and
There's a resolution coming out from one of the council members asking the county to partner with private.
Consider it a hypothetical for right now.
Consider that, yes. There is hypothetically a resolution coming urging partnerships so we can utilize some good water and take away some of the injection well water and use it for landscaping.
Absolutely. This was one of the reasons why we designated the Lahaina aquifer sector in the first place, that we even have the opportunity to even require alternative sources. So if there will be, it sounds more like there needs to be infrastructure funding. Yes, C1 would be supportive of that.
Maybe I'll just add to that as well.
because I think I have a couple of comments on your question, Commissioner Wu. So in terms of Seaworm and our jurisdiction and how we can better partner with other agencies, I think you're exactly right. That is something we can do and need to do and are attempting to do, is be a voice in those conversations with the counties, with private water purveyors. In some cases, including Lahaina, we see the pukas and the gaps, and we understand improvements that could be made, whether that's to infrastructure, R1 facility improvements. We understand what needs to happen in order to quote unquote create more water in these water stressed areas. It's not necessarily our jurisdiction or Kuleana to make those types of improvements or changes to water infrastructure, but we can advocate for those changes, and we should advocate for those changes given our mission and mandate to protect the public trust and water resources statewide. So that's something we're trying to do, is be that voice in those conversations.
You made this a very good meeting for me thus far, so thank you.
You're welcome. And then I will also just mention, I think you've kind of hit on the crux of some of the biggest issue that we're facing is the question of balance and how we do that. Because we have public trust uses, which again are prioritized not in a particular order, but those are things that we are supposed to consider and prioritize above others. Ultimately, it will be up to our commission to make a lot of these decisions when we bring these applications before them, the water use permits. They are going to be the ones making the decisions about who gets what and how to balance and what that looks like.
Thank you, and forgive me for making a very general characterization to lead into my real question. My very general characterization is that these water issues appear in many cases to be a bottleneck. And so my questions are, can you speak to the adequacy of the human resources you have available at Seaworm to get these problems worked on and solved? And then second, and maybe related to that, it seems like when you do make progress and you do get a commission decision, the next thing you do is you go to the Supreme Court for 5 years to get it appealed. How big of a problem is that?
Maybe I'll address the first part of your question, which is related to staffing. The short answer is we don't have enough money and we don't have enough staff. We need more of those things in order to make decisions to understand threats to the resource. In terms of permitting, like processing permits, I won't say I agree necessarily that we're a bottleneck, but I will say that we don't have enough staff.
I ask for your forgiveness on that.
We don't have enough staff to do everything that's needed, and the number of permits that come into us and our ability to process them and do the critical analysis that's needed. It takes time, and we don't have enough staff to make it happen. Maybe I'll defer the second part of your question to Alexa as it relates. I think maybe you want to reiterate it for Alexa. I think there's a legal component to that.
I think I'm hopeful.
So my second question was, you have it's part of your kuleana to make really important decisions to move progress forward in the context of the public trust in which you are in. You are the responsible for upholding. But it looks like anytime you make an important decision, it ends up with the Supreme Court for 5 years. How do you make progress?
Thank you for that question, Chair. Looking at the history of the Supreme Court decisions that I mentioned on the slides, I think there's definitely a learning curve for the Commission to apply the law how the Supreme Court wants us to apply the law. The last opinion, I think we were really close on making coming down with an order that would be agreeable to the Supreme Court, but looking at in the future for the Lahaina aquifer sector area, I'm more hopeful there, given the urgency of getting housing and water to the people, that the parties will be more agreeable to the decision that Seaworm's going to make. But I can't speak for all the applicants.
how they will perceive. If we're telling them the 4 MGD that you're asking for, you will only get 3. So I can't
Fair
can't
enough.
speak for them.
Let me just offer on behalf of the Land Use Commission, when you do come forth with your position, please brief us on it, and if we can do anything to support you, we'll take it under consideration.
Thank you.
So just a few more slides, if you'll bear with me. I did want to talk about the Hawaii Water Plan, what it is, what it is intended to do, and the intersection with land use planning.
So should we take a 5-minute break?
We can.
It's been going
There's-
for an hour, so I'm gonna take a 5-minute.
Sure.
It's 2:04, we'll come back at 2:10.
Sounds good.
6-minute recess. Back on the record, it's 2:11. So let Katie even take it.
Sure. Again, for the record, Katie Roth, Planning Program Manager with the Water Commission. Just to wrap up our presentation, I wanted to touch briefly on the Hawaii Water Plan, what it is, what it's intended to do, and the intersection with land use planning. When the code was written, they recognized that comprehensive planning was an essential component to water resource management, our ability to manage, protect, and regulate the resource. So they envisioned a plan, which we call the Hawaii Water Plan, which is intended to do just that. It consists of 5 separate components. There's a water resource protection plan, a water quality plan. These are considered to be our protection policies when it comes to water. A state water projects plan, agriculture water use and development plan, which includes state needs. And I'll talk a bit more in the next slide about the specifics of each of these plans. And then there's the county water use and development plans. So these 5 components are what create what we call the Hawaii Water Plan. So again, getting a bit more into the weeds on each component, the Water Resource Protection Plan is actually a plan written and drafted by us, by the Water Commission. The Water Quality Plan is prepared by the Department of Health. And those 2 plans are intended to tell us how much water do we have, what's the available resource, and what do we do to protect it in terms of quantity and quality. The State Water Projects Plan is prepared by the DLNR Engineering Division. That gets into more details about water needs for state projects, including those of the Department of Hawaiian Homelands. The Agriculture Water Use and Development Plan is prepared by the Department of Agriculture, and that talks specifically about water needs for agriculture. County water use and development plans are typically prepared by the county water departments, and they are heavily informed by the county land use plans. So the water use and development plans are really kind of where you see the land use component come into play in terms of understanding current and future need, and what that looks like when you talk about like authorized planned use, what developments are on the horizon, what do those water needs look like. Oh, maybe I'll just also mention that each of these plans is supposed to be updated on a 5-year cycle. That doesn't currently happen for a variety of reasons, which makes it a little bit challenging because the plans are intended to talk to one another and be somewhat integrated and operate in a more integrated fashion. Whether or not they do this in the best way, I think is open to debate, and I'll probably be the first to say that they don't do it as well as they could. And that's something that we're working to improve. I don't have a slide on this, but we're in the process of updating our Hawaii Water Plan framework document. The framework hasn't been updated since 2000, but that's the document that the counties and other plan preparers would refer to get more details and insight about how to go about updating their plans, what information needs to be included in these plans, how they think about these plans. So that framework document is something that we're in the process of updating at the moment, which should hopefully lead to better planning and policy.
Chair, I have a question.
Commissioner Lee.
Thanks for bringing up the county plans. Does the state general plan have any part?
The state general plan? I know the county general plans are part of the process that the counties go through. They review the county general plans. I might defer over to Neil. The state general plan, is that in any way involved?
I don't know of any state general plan, the counties do have, it might have been way back in the day that, there's a state functional plan, but maybe planning and,
Mary Alice, you want to speak to that?
I don't think the state has a general plan. I think there are 4 county general plans. Excuse me, ma'am. Thank you. There are 4 county general plans. The state has a Hawaii state plan, which is chapter 226. And it encompasses a wide variety of different goals, objectives, and includes the functional plans and priority guidelines. But there is not a 5th state land use general plan. There are state land use districts, which the land use commission decides.
That's consistent with my understanding too. The county plans, the county has general plans and those are updated on a semi-routine basis.
Yeah, so that's another kind of complicating factor because you may have a county water use and development plan that's being updated, and partway through the update, the county general plan gets updated, and whether or not that information gets inputted into the water use and development plan is not always the case. And that's something we're trying to work to rectify as much as possible. But it is challenging when you have all these different plans that inform other plans that are supposed to talk to one another, and they're all updated on different intervals and cycles. So it is challenging, to say the least.
Chair, I got a question.
Where are we?
Yeah,
Commissioner
we're
Cahill?
here.
Yeah,
I'm still here.
go. All yours.
You know, with Red Hill, Red Hill contamination, I believe Red Hill aquifers fed 25% of Honolulu. So now that that's gone, most of it, have you guys looked at other alternatives? Besides just looking at what we currently have with the Waiholi stream and what we currently generating to our rain reservoirs? Have we looked at the increase in hotels population? How are we going to be making up that loss? Does the commissioners look at alternatives like desalination, maybe solar desalination? Anyway,
It's a good question. So on the topic of Red Hill and the implications of that disaster and the closure of the Halava shaft, which is under Board of Water Supply jurisdiction, Board of Water Supply has had to pivot to use other sources that they have around the island to make up for that loss of source. That is more in the county jurisdiction. It's not something that we necessarily would weigh in on in terms of where they would get water from. But we do work with the Board of Water Supply in developing their water use and development plans. So they're a little bit unique. They don't have one island water use and development plan. They have several, and they basically make different plans according to different mokus across the island. So they have, I think, about 6 or 7. They call them watershed plans, but those are essentially their water use and development plans. They have a plan in draft form for the primary urban center, which I believe covers the Pearl Harbor Aquifer where Red Hill is located. So within that plan, it will hopefully discuss ways to rectify source issues and as it relates to Red Hill contamination and what they can or cannot now pull from that aquifer.
thank you.
So the Hawaii Water Plan and how it intersects with land use planning, it really kind of relates directly to these water use and development plans. Within our statute, within the water code, within our admin rules, and within the framework document that I mentioned, there are specific requirements / recommendations that the counties need to include these various things, kind of a checkbox when they're writing the plan. So they do need to identify existing and future land uses as it relates to water needs. They need to make sure their plans are consistent with respective county land use plans and policies. That includes the general plans, consistency with state land use classifications and policies. These plans look at a 20-year planning horizon, so looking out ahead 20 years for what the water needs are, what development looks like in the next 20 years. And again, they're supposed to be consistent with other components of the Hawaii Water Plan. So when these plans, these components of the Hawaii Water Plan come before the commission for adoption, we do look at these checkboxes to see if they're met. So we do want to ensure that the counties are talking to, you know, their planning departments, that land use is considered in the development of these plans, because we know that the intersection between land and water is critical, but they haven't always been talked about, I think, as one. So that's something that we look at when we're adopting these various plans. Also, when water use permits are taken before the commission, we will, you know, have a section in the submittal that says, is this project consistent with the Hawaii Water Plan? So not all developments are listed within these water use and development plans, but we would want to refer back to them to see, like, yes, this is a development or a project that was listed in the county's water use and development plan. We know that there's, you know, source available for it, or they have at least the infrastructure in place to make the project happen. Just a couple more slides left. So one thing I think we wanted to discuss was how our processes can be better integrated, and things that we felt would be pertinent or important for you as a commission to think about when you get land use petitions coming before you. These are things that you may or may not be thinking about, but I thought it was important to include here. So changes in water availability, you know, I think this definitely applies to petitions or amendments to projects that are coming before you that maybe were approved decades ago and haven't been built, where at the time, you know, the water situation was different. But we need to consider what's happened since then. So changes in water availability, you know, we mentioned climate change is something we're seeing statewide. There's just less water available. And that has led to us having to designate new areas. The end of sugar, as you mentioned, sugar is a very thirsty crop. That led to a lot of, you know, recharge in particular areas, but we're not seeing that recharge anymore because there's no more sugar crops. We're just starting to kind of feel, I think, the impacts and effects of that, where we are seeing less recharge in some of those areas because there isn't all that water being recharged into the ground. The effect of invasive species, both animal and plant related. Many of our invasive species, plants in particular, just suck up more water. So where you have, you know, high concentrations of invasive species, you're just going to see less water. And I think, you know, this relates back to Forestry and Wildlife and the work they do for the Land Use Commission to be somewhat aware of where projects are happening to restore watersheds, where active management is happening to remove animals. In places where you are seeing that active management and forest protection and restoration, the hope is that they're, you know, we're protecting the source and hopefully creating more water, at least ensuring that there is going to be water available in the future. Updates to our sustainable yield numbers. These haven't been updated in some time, but we just got a new report from the U.S. Geological Survey, actually looking specifically at the impact of climate change on water resource availability. So we're in the process of taking that data and analyzing it to update the sustainable yields for our aquifers statewide. What that looks like, I can't specifically say, but in many cases, we probably will see a reduction in sustainable yield, which means there's going to be less water available for us to allocate if we're looking specifically at sustainable yield as our measure of what we can and cannot go above. We also need to consider where interim midstream flow standards have been established. I mentioned these are ongoing, and we're establishing new flow standards every year. Newly designated water management areas, as I mentioned, this just kind of brings into a whole new regime of permitting and process into the conversation. So where you are looking at petitions that are within a designated area, I think it is important to get CWRM to consult specifically on those types of petitions. water infrastructure requirements. A petitioner may come before you and say that they have the water, but I think it's important to probe them to make sure you fully understand what that means. Does a new well need to be drilled? Is the county supplying this water? You know, what does that actually look like? And again, prioritization of public trust uses of water. That is, you know, our duty to understand what comes first or what should be prioritized ahead of other uses. So the current engagement of our, yes,
Can you go back?
sure.
I was holding this question, but
Sure.
since you have it on the slide. Do you have, where is your confidence factor in terms of the sustainable yields that are advertised and presented to this commission and others?
Well, as I mentioned, we're in the process of updating them. So I can't give you a timeline for when that will happen, but it's a priority for us to update them as soon as possible. Sustainable yield information is found in the Water Resources Protection Plan. So that's probably the plan that will be updated, probably just the section on sustainable yields when we complete our analysis. We're having ongoing conversations internally about how we're going to go about doing this, whether it's focusing first on what we would consider like hotspot areas or places that we know sustainable yields may be going down. West Maui could be one example of that, and kind of updating the numbers on a case by case basis rather than statewide all at once.
So when it comes to the question of sustainable yields, your go-to contractor is USGS?
No, we can actually run that analysis internally using what we call a RAM model. It's a pretty simple equation, and there's folks who have opinions about whether or not that current form of analysis is the best way to go about determining sustainable yield. So that's part of our internal conversation, whether there needs to be a different approach to how we create these numbers and come up with them.
So if a new development comes before us and as part of the presentation, maybe even part of an EIS, they've hired a private consultant to address the sustainable yield. Obviously, it's in the developer's interest for that to be as big a number as possible. But I'm more interested in it being accurate. Are you a resource that the LUC can look to for a second opinion on a sustainable yield for a particular parcel of land?
Absolutely, yes. And if you wanted to confirm the number they're presenting to you, you could look in the Water Resource Protection Plan. We also have that information on our website and maps.
So I offer that as a lead into your next slide.
Yes, thank you very much. I appreciate that. So in terms of engagement, I just wanted to maybe reiterate the current process as I understand it. I've only been in this position for 2 years, but based on what I can gather, the way that CWORM currently engages with the LUC is petitions will get routed for comment to our agency, but they're getting routed through OPSD, which then sends something to our department, to DLNR, which then goes to our land division, which then disseminates to all the divisions within DLNR. As you can see, there's a lot of things that could get lost in that process. So we may or may not receive the petition or receive, you know, a request for comment for what we would call a doc review. In some cases, because, you know, it's disguised on a land division letterhead, it may not trigger in us, this is, you know, a land use commission issue, or even the, you know, the high priority that it may need. So that is the second bullet point I guess I wanted to mention is, can that consultation process potentially be improved upon? I don't think there's anything that precludes our agency from working directly with LUC staff or vice versa for them to come to us directly. I have offered up planning as that point of contact. If there are specific questions that need to be answered, we are happy to do that, and we will make that a priority.
Yeah, I think that could work, and I'm offering an olive branch to my friends over here in OPSD at the same time, because typically we'll get a petition and our staff is of a certain capability to identify whether we're gonna have questions on water as a priority. And if and when that, so we don't have to send everything to you.
Right.
But when we see a petition in which water is a prominent issue, I think it's a three-way that we cannot let something get lost in the sequence of events. And we would welcome your presence, your involvement, your attention to the water issues as part of the process that we go through with OPSD. Absolutely. Yeah.
Yep,
Fair enough.
definitely.
Yeah.
Chair,
Where's that?
over here.
You. Okay, Commissioner Carr-Smith.
I just wanted to confirm or clarify, so Seaworm would be involved if we were dealing with a petitioner that's in a designated area, right? If it's not a designated area, then it's the county,
Well,
correct?
in any area of the state, we could weigh in. Just because an area isn't designated doesn't mean that there may be water issues, water conflict. So I think if the LUC feels that there could be pertinent water related issues, regardless of if it's in a designated or non-designated area, we have the purview to weigh in.
I don't think it's an either or. I think at most of our petitions, we've got both the state and the county present. And we would welcome you to be part of the commentary offered by the state on water issues, but that doesn't preclude representatives from the county that have a similar role.
Exactly.
Right.
I would encourage that idea. Yeah.
Yeah, I think my suggestion here is that perhaps in certain cases, Seaworm should be the entity representing its, comments rather than OPSD.
Yeah.
Not to say anything negative about OPSD, but it is challenging with some of these issues, which are very complicated. If they just have a conversation with one of our staff and have to communicate that back to you, it's difficult. And so I think it would be better if Seaworm staff, one person at least, could attend the hearing
Yeah.
to provide more detailed comments that may come up, which is something I noticed when I looked at the recording from May, the LUC meeting in May.
Well, good. Well, we would welcome that, and it wouldn't be groundbreaking. In other words, it might be groundbreaking for Seaworm and LUC, but we've had petitions where the Department of Transportation or the Department of Education or the Department of Health was needed to address prominent questions within the petition, and OPSD has brought those representatives forth
Yeah.
so that we could hear directly on
Great.
occasion.
Yes, and we are happy to do that.
Yeah.
I know that many or some of these meetings are in person. If it's on island or if we have the travel budget, if you're doing a hearing off island, we are happy to participate. If there's a virtual option, even better. We do a lot, even our commission meetings are a hybrid. So we offer both in person and a hybrid option for attendance.
We're similar.
Great, okay. Another, area where improvement maybe could be made is better coordination between the counties and the LUC when it comes to outreach when they're updating their water use and development plans. I believe there has been a conversation in the past about amendments to the LUC admin rules, specifically maybe calling out more explicitly consultation with the Water Commission. I know nothing has really moved on that for a variety of reasons. But maybe an alternative to a admin rule amendment would be to devise some sort of memorandum of understanding.
Actually, we're in the middle of updating the admin rules presently, so over the next weeks to months, and the opportunity is now.
Great. And again, based on my understanding, I think we have provided suggested language to LUC staff for those admin rule amendments. So we can continue the conversation if needed, but I think we have some suggested language. So in addition to that, we could also come up with an MOU. Seaworm has MOUs with other agencies, including the PUC. These are, non-binding, but it, lays out in a very specific way opportunities for collaboration, holding us accountable. We may want to call them, I guess, promises or commitments to work more candidly with one another. And this has worked well for us. And this is kind of something new that we've done in the last few years, just to further articulate the relationship and the importance of interagency collaboration. And with that, I will end. Thank you so much.
Thank
We're happy
you.
to answer
Yeah.
questions.
Commissioners? Further questions or comments? Commissioner Yamane?
Hi, I had a follow-up question relating to sustainable yields. I just wanted to confirm that you need the data from the deep well monitoring to do the sustainable use. Is that correct?
That informs it. It's not, I guess, I don't want to say it's not necessary. It informs it. It's one component of that analysis. But it's not the only component.
What is the components to have a high confidence report on sustainable yields?
Maybe I'll ask Neil to weigh in since he has a bit more familiarity with the process we've gone through.
Thank you, Commissioner, for the question. Yeah, so currently the Water Commission utilizes what we call best available data to estimate sustainable yield. In the past, we've been using different recharge, how much water makes it into the aquifers. And based on that amount, we call it the recharge. There's different ways to estimate what the sustainable yield is in order to sustain the aquifer. And it's, sustainable yield is defined in the water code as, I can't quote it for you, but it's the amount of water withdrawn as to not harm the aquifer as determined by the Water Commission, right? So it's not a specific quantitative thing, but it's based on science and judgment of the commission ultimately. So recharge data, we call it, we use best available data to estimate sustainable yield. What the commission currently uses and has been using is a very simple kind of a water balance model. And it's basically how much water going in, how much is allowed to flow into the ocean, and whatever proportion of that is through different formulas. The remainder is what's available to be withdrawn up to a certain point. And then once you hit that point, you gotta stop. So
Water going in, is that rainwater then, when you say water going in?
yeah,
basically.
generally it's the rainwater, it's the land use, the type of land use, ground cover, evapotranspiration, a number of components, including stream flow and how much of that stream water goes into the ground, things like that. The most recent USGS study actually looked at reservoirs and what that contributes to the recharge of the aquifer. So it's very detailed. So I forgot what the original question was.
I mean, I think the simple way to say it is we take the data, USGS data being one example, and we plug it into our RAM or robust analytical model to generate the sustainable yield.
Okay, I guess I was thinking that you didn't have enough data, so I was curious whether the output of the sustainable yield system was not high confidence, but it seems like it's more than just the deep well monitoring that you're getting the data from that contributes to the sustainable yields.
Yes.
We actually have two RAM models. So the basic RAM model and the RAM2 model, that second model relies on data from deep monitoring wells. So those deep monitoring wells are in fact very important. So the more information we have from those, we can make better projections on what the sustainable yield really is.
Thank you. No more questions, Mr. Thanks.
Anybody else?
Chair, I got a point. I want to circle back. Sound like we're in trouble. We'll be in trouble in the next 10 years. Yeah. So going back to alternative sources, I know the Board of Water Supply, we're looking at a desalination plant in Campbell. Have that resurfaced, or is that being currently?
Neil?
Yeah, I think they are going forward with a pilot desalination project in Kalailoa.
Yes.
And I think I kind of want to speak for them, but it's about looking at about 1 million gallons a day, maybe. I don't want, so that's probably a better question for the Board of Water Supply, but yeah, those are kind of alternatives that the Honolulu Board of Water Supply has been pretty progressive with looking at. They use recycled water in Honolulu for irrigating their, landscape irrigation and things like that. So that's a great example of alternative water sources.
And I will just add that, desalination, that's a very expensive process. So I wouldn't say that that's necessarily where we need to be headed. It is one option, but it is quite expensive to do that. Maybe I'll just kind of take the opportunity to mention our water audit program, which I didn't mention in the slides, but Neil and Nick lead our water audit program, which basically is an assessment of water systems to understand where efficiencies could be made, fixes could be made, repairs could be done to achieve greater water efficiency, so fixing leaks. So they do that annually. And Neil, I don't know if you want to comment more on that, but that's one way that we're trying to figure out how do you create more source is just by plugging the holes, essentially.
You know, I'm not a real good golfer, but I love to golf. We have 60 courses, I believe, on the island of Oahu. So I was just kind of curious, you know, with this this plans that's coming out in Kalailua, you know, whether would be able to use it for some of the golf courses, and it could be built elsewhere on the island.
Yeah, that's a great question. A lot of there's across the state in different islands, there actually are recycled water. We call them recycled wastewater, treated to a certain level, and they actually do irrigate golf courses on Kauai, Maui, including Oahu. I think some of the Ewa golf courses are irrigated with the Honolulu recycled water. So I don't want to give any numbers, but the Honolulu Board of Water Supply is doing that. So that is definitely an alternative that's actually in practice. Yeah.
Thank you.
Okay, I think we're good. Do you have any other comments or questions?
I don't think so. Thank you all for the opportunity. It's been great.
No.
Chair,
Oh, where am I?
could we ask to get a copy of the presentation? Thank you.
Yes, it's been shared with LUC staff.
Yeah, staff.
Thank
has it.
you.
So we'll have staff distribute. So what's the plan? Are you gonna just post the PowerPoint? Or do you want to send it out to us individually?
I will post both PowerPoints presented today on the LUC website.
That'd be great. That works, yeah. Yeah, on behalf of all my fellow commissioners and staff and OPSD, we want to thank you all for coming. It's been very informative and very timely. So thank you. Thank you very much. One second, just let them. This concludes our meeting. We are adjourned.